Well, one thing that Taylor Swift, Katy Perry, Ed Sheeran, and Led Zeppelin have in common is their talent and popularity. Another is that they all made headlines in recent years, months, and even weeks as parties in music copyright disputes. Music copyright is an important and dynamic area of intellectual property law, and as technology and the legal rules evolve, it is important that those who live and work in the ecosystem, artists, recording companies, musicians, attorneys, judges, and even social media influencers keep abreast of the nuances. That's why I decided we should start the year with this music copyright infringement conference. And in this endeavor, I'm delighted to have the opportunity to collaborate with Professors Bob Brauneis and Charles Cronin. I've enjoyed our many planning meetings, and I'm pleased we are able to offer this conference as a platform to amplify their music copyright infringement resource. It's an impressive database of music copyright infringement cases for the mid-19th century forward in the US and to an increasing extent in foreign jurisdictions. Our goal today is to have a conversation about how different jurisdictions address common challenges of determining what has been copied, what is protectable, and who gets to decide. At the end of it, I hope we will start to see new ways to learn and work together across countries as we have across institutions. And along with my co-organizers, I want to add my thanks to David Wright for sponsoring this. David's Wright, beg your pardon, for sponsoring this event. I also want to acknowledge the IP Center's annual patron sponsors, Gen Law, McAndrews, and our annual sponsors, Greer Burns, TransUnion, and LADIC for their generous support, as well as our 13 institutional partners. So again, thank you very much for joining us, and I look forward to personally learning a lot about music copyright infringement in Asia, in Europe, and in the US. Thank you. Over to you, Charles or Bob.
It's going to be Bob first. So thank you, Daryl, and I want to extend also my welcome to the 67 countries represented. That's an absolutely wonderful and astounding number. And I want to thank both Charles and Daryl for their collaborations. Charles, of course, founded the Music Copyright Infringement Resource and has been diligently working on it and expanding it for years. He was kind enough to come to me back in 2018, 2019 and suggest that it be moved to GW. And we're very, very happy to have it here. And we're very, very happy to have this conference kind of built on the groundwork of that resource. And thanks also well to Daryl. As Daryl said, we have had many planning meetings and they have all been cordial and productive. And so I appreciate, Daryl, your involvement as well. And of course, your gift of this wonderful platform, Remo, which I think, as the participants will see, shines even better in the breaks than it does during the panel session. So I'm going to turn it over to Charles now. Luckily, we're in the same building because Charles' computer is not working. So I'm just going to slide off stage left, and Charles is going to enter.
And here I am. And I will be as efficient as possible since I am eating into my own time. But thank you both, Daryl and Bob, for acknowledging the Music Copyright Infringement Resource, which is a clearinghouse of information and documentation and also original commentary about music copyright infringement disputes. And one of the an impetus for this discussion today, and the topic, in fact, came in part from the fact that increasingly we're documenting and receiving documentation from friends around the world about litigation involving music copyright infringement disputes from nations beyond the US. And what we're hoping to discuss today is what I think of as a very heavily used term, substantial similarities between national jurisdictions, but also divergences in the litigation and disposition of music infringement disputes, reflecting both various musical and also legal. And I hope this meeting will give us an opportunity to discuss some of those similarities, commonalities, and differences among legal and musical cultures. I also am delighted that this is I think this gathering is one of perhaps the first opportunity or the first example of a meeting that involves both copyright experts and also musical experts, and in some cases experts that are experts in both. And when I say musical experts, I mean what I call real musicians, which in my view means literate musicians, and we will hear from literate musicians at various points throughout our discussion today. And of course, I also want to thank Davis, Wright, and Permain for their support of this conference. And we will be hearing later on from Peter Anderson, who's very well known litigator in this area, and in fact successfully represented Led Zeppelin in the prominent litigation that was resolved only quite recently. I think I can now turn to the Asian panel, and I am assuming that all of our Asian nation panelists are among us.
Hang on, Charles. Let's get a group shot. Get Bob back in, and then we can do a quick shot before we start.
Okay. Yes. So
all right.
This is Charles, and that's Bob.
Frame.
Okay.
Okay. All right. We got it. Thank you.
So the first question, or the first issue that I wanted to broach with you, is the question of who decides litigated music infringement disputes in your jurisdictions, in your country. Is it judges? Is it jurors? Is it experts? In the U.S., all three participate in deciding music infringement cases, and often there are surprising outcomes. And the Perry case, very recently, there was a surprising, not a surprising outcome, but some time ago, there was a potentially surprising outcome in that a jury verdict was overturned, quite a rare, which puts in conflict the opinion of the judge, the juror. In the U.S., there's a strong deference to juries, otherwise known in this context as lay listeners. And Jesse, I wanted to broach first with you the question of who decides, because I remember in our discussion you were talking about that in Taiwan there's no input from jurors in these disputes, and I wondered how could you talk a little bit about that, and if possible, also a related question, and that is the role of experts. If you're not informed by jurors, are you informed by experts? And what type of who are the experts? Are they court appointed? Are they supplied by the parties? Are there no experts? And one further sub-question to that is, what sort of information do experts provide? Assuming there are experts, oral information, is it so-called neutralized information like MIDI files, etc.? So let me step back, and Jesse, about Taiwan and some of those issues and how they play out in Taipei.
Okay. I think I will try to introduce cases in Taiwan. The first one is called Liangsan Love Song case. You can search some information in the music copyright infringement website. So I think in this case, this case happened in 2008. The judge tried to make his own decision, because I don't know why the judge just didn't ask any expert try to provide professional opinion or testimony. But very interesting case because the judge didn't hire anyone to provide opinion. So he tried to make a musical score by himself. But the problem is in Taiwan, the judge just has a legal background. They don't have any musical background. He's patient and try to write everything down, any kind of evidence he had, and try to put into decision. The other case I would like to introduce to you is Sleeping Beauty case, 睡美人案件. It happened in 2011. In this case, the judge to expert to provide professional opinion. The first one came from a very prestigious music school in Taiwan, Furen Daxue. It's a Christian university. And the professor is very famous and very distinct on classical music performance and composition. So in this case, the expert tried to prove the substantial similarity is above 90% percentage. The other expert tried to compare two songs and also said the substantial similarity is proved. So I think in Taiwan now we moved forward and we try to depend on expert to make a decision, because I think this is more stable and more reasonable and more liable, and he can really help judge to make a decision. Just like I say, Taiwan, the judge doesn't have any musical background, because when they finish their law degree, they got a bachelor degree of law. They pass the exam, your judicial exam, they become the judge. So they need some helps. So I think that's a very good way we can learn from the US. You know, maybe we can try to start to appoint expert to help the judges. But the problem is, I think we don't have any knowledge when the expert should step in the cases, because I think sometimes the judges appoint some very powerful experts. Their opinions will be very powerful. So I think because the judges don't have that kind of ability to decide the substantial similarity, so maybe he will cause some problems, because I think the expert has the position, a very neutral position, will bring some pretty negative effect. If you hire someone, maybe, not very, just like I say, not staying in a very neutral position, you will bring some kind of controversies to the cases. So,
Jesse, if I could just interject that. So, am I correct in understanding then it is always a court-appointed expert? The individual parties never bring their own experts to trial.
From my understanding, in Taiwan, currently the judges always make the decision to appoint the expert. But I think both parties have the right to provide some kind of evidence. But I think this is just some kind of references. So the amicus brief is Taiwan. We should learn from that, because we need to collect more information, so the judges can learn from that. But I think now currently Taiwan more the higher, because they think they did some research and they don't want both parties try to try to control the results.
So in both of the cases that you mentioned, did the expert opinions were simply subscribed to by the court, and they agreed with the experts and
Yeah, I think now in Taiwan the experts are quite powerful. But the other question is about what kind of evidence they can provide. Right. For example, they can listen to the music, or they need to write make their own musical score. I think this is a very tricky thing in Taiwan. We don't have any rules in Taiwan. So he seems in these two cases, the judges doesn't care about this. They just try to, I think, accept both kind of evidences. Yeah, they listen to the music and they also observe the musical score. But I think in the future, Taiwan maybe need to move on. For example, I also do some research about the cases in China. I think we face the same problem now because, yeah, we don't know should we adopt the sound recording as evidence. Yeah, what kind of method approaches we should do in the future. Yeah.
Mm-hmm. Okay. So I'm also interested in back to the issue of these deliberations, and maybe other members of the panel could participate now and discuss a little bit about the role of the jury and who decides in India, for example, and in mainland China, in Japan.
Should I go ahead? I just
Please.
want to add, thank you, Professor, and hello, everyone. Well, it's Holi today, so we are celebrating the Festival of Colors in India. So, happy Holi to everyone. And so, when if I break down the query in two aspects, one is who decides the issue pertaining to infringement. India is a peculiar jurisdiction where you can invoke both civil and criminal remedies for copyright infringement. So there are two parties who can decide. One is the judge of a commercial court. So it's treated as a commercial matter. It's a commercial dispute in India. It's not just a civil dispute. It's more narrowed down to commercial dispute, which has to be expedited. The whole process has to be expedited so that there is there can be summary trial. There can be expeditious trials. So it's treated as a commercial dispute. So the judges, they decide the question, the issues on infringement. And also if it is, say, anti-piracy, then you can directly go to the police for execution, for raids, for anti-piracy operations. So there are, when I say who decides the question of infringement, there are two verticals, especially the judges and the executives, the police, the enforcement agencies, they both can decide upon the question of infringement. When I particularly talk about the commercial dispute, when I talk about the civil infringement, then the question of the tests that are applied, they are generally applied by the judges, the court, and the court only mulls over the fact. They put the facts on the test. Say, for example, if they are applying substantial similarity test, or they are applying de minimis test, or any of the doctrines, then they would compare the works, the judges themselves. I have not seen instances where experts are involved in deciding whether a work is infringing or not. So it is largely what we have seen in India is that the judges, they decide on merit, both at the instance of preliminary as a prima facie case, and also as well as after the trial, after the evidence is laid. So it's primarily
without any input from a jury. No, no jury is ever.
Jury, yes, there's no provision of jury in India, and because it's a commercial dispute, it's the commercial division, the specialized courts which have been incorporated for commercial disputes, all the copyright matters, all trademark matters, all IP matters for that matter, they are adjudicated before a commercial dispute, commercial court. So there's no concept of jury, there's no concept per se of an expert witness in most of the copyright infringement matters pertaining to music.
Mm-hmm. Okay. Are there any other thoughts on this from other members of the panel? And if not, I want a related issue, but who had further ideas on this particular to voice them.
Professor Cronin, this is Lily. So
Hi, Lee.
I would like to introduce a little bit about mainland China practice. So so in China, we also do not have a jury, and the judge will decide the infringement matter. However, the expert will play a very important role to help the judge to make the decision, especially the appraisal opinion by the experts from the certain appraisal organizations. For example, like the Music Copyright Society of China, they will help the court either invited by the parties or appointed by the court. Either ways, they will review the music, compare the music, and they will have a opinion to whether like how much similarity between two songs. And those kind of appraisal opinion will be very, very important basis for the judge to make the decision. Because like JC said, most judges, they do not have the professional knowledge about music.
So the provisional opinion is almost always accepted as the ultimate opinion.
In most cases, they yeah, and also there are another kind of expert. So like in some very complicated cases, and the judge, the parties may invite some expert witness or expert assistant to explain more for the judge. Sometimes the judge may even ask the parties to invite their experts to during the hearing, and the judge will ask questions. But those kind of experts will be treated like stay in the same side of the parties. So that will be only reference for the judge. But the appraisal opinion will be much more important for that.
Okay, that's interesting. You've raised this question. I wanted to get back to an issue that you broached when we spoke earlier or some time ago, and that is the fact that in China, many of these mainland China, these cases are often criminal cases rather than civil cases. In the US, there are no criminal music copyright infringement cases involving substantial similarity. That's just not it is possible to have a criminal copyright case in the US, but not in this area. And I was wondering, how do you think the fact that these are commonly criminal charges or criminal allegations, how does that affect the adjudication of music infringement disputes in mainland China?
But first I would like to clarify that the criminal liability for copyright infringement in China actually is limited to two types of infringement. The first type is copy and publish. The typical case would be like sell music CD or flash driver without authorization. And the second is disseminate the music via the internet, but that only limit to the form that the music is provided in form of play on demand or like download from the internet. The typical case would be like someone set up a website and provide some songs in form of play on demand or provide download service. And the infringement of all the other rights are not applicable to criminal liability. Like plagiarism.
Similar to the US.
Yeah.
In that respect.
Yeah.
It's like a willful infringement for economic gain. It is that the Chinese government does not pursue allegations of infringement that involves substantial similarity. Okay, so in that respect, it's actually quite similar to the U.S. But this leads me to an issue that Troy brought up, and that is the changing attitudes in mainland China about copyright infringement. And the fact that the economy has moved from a purely socialist to a socialist market economy, how has influenced attitudes, particularly among younger people, about infringement and copying, if the works are owned by private citizens or private companies rather than the government? How has that changed the dynamic? How have I think you've studied in ethos among younger generations. Troy, do you want to follow from that?
Yeah, thank you, Charles, and I really appreciate the opportunity, and also, it's a learning opportunity for me as well. We have the practitioners, in the panel, and I'm more from a cultural studies background. For my PhD project is about Chinese music industry and also copyright protection. So I look at the historical development of Chinese copyright law from a socio-legal perspective. So it's not entirely, what is on paper and how it is enforced in courts and in how it is adopted in everyday life. So I think the reason why I mentioned the changing ethos of people's attitudes in terms of copyright, it has to do with the historical development of the industry, including the music industry in China. A little bit of background is that, in China, before the opening up and reform, we didn't even have a copyright law. It was stipulated in 1991, 1992. So at the time, we see the changing ownerships, state-owned to multiple ownerships like state/market orient privatized entities. So I think that actually underpins a lot of the development and the problematics nowadays we're facing in mainland China. One observation is coming from the fandom study, research I did in the past few years, and also from a personal level. When we were having, in high school and in college, all the music we consumed are largely, for free, because it is widely shared on the internet. We may purchase and go to concert. That's how the dynamics played at the time. I think because China had a history of the state ownership, it's Gaofei system. It's a state patronage. The rights are owned collectively by the composers, musicians. So when the privatization take place after the open up reform, there is a combination of the universality and the territoriality principle coexist when China joined the TRIPS agreement. So I think to nowadays, in terms of the law on paper and the kind of rights being protected is largely similar to the other signatory countries. However, in terms of practice, we still see problematics and power dynamics going on. We recently have the third copyright amendment, took effect, and we see a lot of new changes in it. In terms of Lily just mentioned, the certain cases can be criminalized, and they have more, for severe cases they get more fines, and also the protection extends to the internet and in more significant ways. One thing I want to talk about, because of such these different systems cleared in the digital age, we see the power dynamics change between the more established record industry, when a lot of infringement are actually cases brought up by them, and international players were involved as well. Because at the time, I'm just invoke two colleagues who are writing about a generation with a cut. So when pop music were introduced or exported in China, export quote unquote in China, or sort of dumped into China's East Shore as the plastic waste, because those records were not that popular, or there is they cannot be sold in the original market when they were created first. So that actually were curated and also nurtured a generation of new musicians for different new music genres. So that's the earlier days. I think it's a bit of history we need to bear in mind when comparing different judicial practices and also systems. So departing from that age, now we have the sort of tech giants wrestling, competing with the more established record industry in China. So I think that's the kind of problem where we were actually expecting the Third Amendment to come into place for so long, and there are different lobbying efforts, struggles between those entities. So now we are moving from the legacy, the physical good perspective to more digital, rental access issue. And in between, there was a model, where I spoke about my personal experience. I think Lily may share some of the experience as well, where everything basically is free. This is based on also IFPI and China's Music Copyright Society, their reports. At the time, it's around 97% or more of music were actually, consumed, freely shared online. And that actually, normally you would think people would go to litigation procedures. That's what a lot of international, especially American entities, companies, they went for. However, the reached agreement, and Baidu, one of the key players, at the time sharing music on their search engine for free, was actually taken off from the 301 report, stipulated by the U.S. government. So you see these litigation procedure used as a kind of business strategy to actually, turn into copyright violators or even competitors into collaborators. So I think that's the dynamics I would like to provide to give you a bit of background. Nowadays, even though you see copyright as is in people's awareness, within fandom, they will protect their beloved stars, idols, if their music was sort of plagiarized or violated. So we do see such passions going on within the fandom community as well. So
interesting, because
yeah,
paradoxical that with the development of technology that makes copying and distribution so easy, that there would be a growing sensitivity to infringement in mainland China. So there's something more than the technology itself. It seems that's the shift that is affecting the industry.
Yes, I think a lot of tech giants, for example, Douyin, and also widely or better known in Western context as the TikTok, a lot of them are lip syncing and reusing, sampling music that is already tested, popular, in different markets. So I think that actually raises a very interesting and challenging case for different markets as well. And we and my colleagues at Nottingham, we published a paper recently talking about the development in terms of technology and also institution over the past 10 years. And we used the TikTok case and also a lot of fast facts, from the industry and then also practitioners. I mean legal practitioners. So in China, I think Lily know better than I do in this front, because for music infringement in short video sharing platform was actually heavily litigated in China, you see exponential growth in such litigation process, cases.
Yeah, I was about to mention that. In fact, I was going to ask Lily, you must be busy, and increasingly this phenomenon is coming to pass. Are you increasingly finding private with infringement claims?
Yeah, as a lawyer, we do have seen more cases in China, and actually, all of those litigations have largely helped the Chinese people, the Chinese companies to be aware of the importance of IP protection. And we have did some data research in China case database, and we can see that in the past 10 years, the types of music infringement cases have changed in a very interesting way. Like from 2012 to 2016, most of the online music infringement was filed by the online music platforms to other online music platforms for providing music and downloading service without authorization. And that's the same time for some giant internet companies like Tencent Music start to purchase the exclusive license of music in China. But in the past 5 years, these kind of cases have decreased largely, and the other type of music infringement has increased. That is the infringement of music in like movies, short videos, and so you can see that like the market has been educated by those litigation. But I also want to raise a very interesting topic here that I think in the next 5 years, the situation may change, may continue to change, because the motivation for the music online platforms may be decreased because exclusive license of music has been forbidden in Chinese market since last year. So last year, Tencent Music was punished by the Chinese government because of antitrust issue, and they were ordered to terminate all of the exclusive license of music, to change it to just normal license, to allow other platform also can get the license of music. And the China Copyright Office also ordered that the platforms they are forbidden to purchase the exclusive license of music. So this kind of order are very controversial in Chinese market, and I think it will, of course, impact the music infringement situation in China maybe in the next 5 years. Yeah.
And Lily, if I can stay with you for just a moment, because you raised another interesting question when we spoke earlier, and that was about damage awards and who makes the decision. In China, that unlike in the U.S., it's where there's some choice in this. And or my impression was that the government does, or the court decides which type of award to consider infringement cases, whether they're statutory or actual or compensatory or consequential. Can you talk a little bit about that, and how is that changing, or how does that affect disposition of these disputes? And I think, if I remember correctly, you intimated that the were recommended or established by the court were tended to be very modest, and compared to what you might find in other jurisdictions, other nations.
Yeah, because the copyright law actually provide three three calculation methods for the damages, like the economic loss suffered by the plaintiff and the illegal gains obtained by the infringer, and the last one is the statutory damages decided by the court. So, but in the majority of the IP cases in China, the Chinese judges will grant statutory damages, which is the easiest way for them to decide a number by discretion without explaining specific calculation methods. Normally, the court would comprehensively consider every relevant factors and directly reach to a specific number. And the considerations may include, the reputation of the music, the reputation of the author, the period of infringement, and the bad faith of the infringer, things like that. But in the rare cases where courts did adopt the economic loss of the right holder or the illegal gains of the infringers to calculate damages, the plaintiffs were asked to, provide very solid evidence to prove the exact amounts of economic loss suffered from the infringement acts or the illegal gains of the infringers obtained directly from the infringement acts. For example, in cases where the defendant happens to be a listed company and who has published the profits from the infringed music in its annual report. And in the meantime, there is a generally recognized percentage of IP contribution to the income of the industry. Or maybe the judge is really open-minded and forward-thinking and aggressive to just estimate a percentage, such contribution percentage. So as you can see, it's very difficult for right holders to collect such detailed evidence. And also it's a really big challenge for the judges to make such decisions. So no wonder, judges will choose the easy way, just to work into the statutory damage. And as you mentioned, I have, so some local courts even issue very detailed guidelines for the judges to decide the statutory damages. Like the Beijing Higher People's Court issued such guideline. They will have this recommended statutory damage for each type of IP infringement case. And the damage is not quite generous. For example, like for music infringement in forms of copying, publishing, or distributing in the internet, the compensation to the authors should be no less than about $95 US, and 40% of that shall belong to the lyric writer, and 60% shall go to the composer. So, as you can see, they're not generally compared to
thank you very much for that clarification on a very, very sticky and very complex issue. I want to jump back to see, Pat, if we can get you involved in this discussion, because I wanted to go back to the question of experts and the testimony that they can provide in resolving substantial similarity issues in music infringement cases. Pat, I know you've done a lot of work with the development of algorithms for predicting potential infringement, and also for evaluating both originality and similarity. And I wanted to hear any thoughts that you might have out this to establish musical similarity and to inform infringement disputes. And specifically, there are a couple of questions that I had. One was whether your approach and your algorithms are focused on audio data or purely musical data, and whether you've seen any variance across different musical cultures in applying these algorithms to quantify musical similarity.
Thanks very much, Charles. A pleasure to talk and to contribute to this panel. So just as you say, you know, my experience here is more from the musicological and sort of computational comparative musicological side. So I'm less familiar with the details of each individual jurisdiction. You know, I live and work in Japan. I sing Japanese folk songs, but I'm not an expert on Japanese copyright law by any means. But we have analyzed a bunch of cases in Charles's database, which is, as people have already said, is a great resource. We started off with about 20 published a couple of years ago, and I'm currently helping my master's student do an expanded analysis of about 40 songs in the database, which includes several from East Asia, several from Japan, several from mainland China, one from Taiwan. And so it's, you know, it's not enough to make any really big universal claims by any means, but the methods that we've developed initially for kind of the US context, which is very much based on melodic similarity as represented in a score. They've worked pretty well on these 6 East Asian cases. In fact, they seem to have worked better on these East Asian cases than they have on the US cases. So, you know, the algorithm never predicts decisions completely. It kind of, so far we're kind of finding like 70 to 80% rate of predicting past cases. But for all these 6 cases within East Asia, it's actually predicted very well. So if it's more than 50% identical in terms of the notes, all these cases have found infringement. If it's less than 50%, they've found no infringement. Now, whether that will hold up for many more cases in East Asia or other regions of the world, I can't say. And most of these East Asian cases are also sort of globalized pop music. So it's not like traditional Japanese music in most cases. It's more of a, you know, J-pop or post-war kind of American influenced jazz that's written in Japan. But there does seem to be something quite powerful about just, you know, melodic similarity as a strong predictor of copyright infringement in these, even in these East Asian contexts. So, you know, the quantitative methods and counting the number of notes and measuring present similarity was never going to solve every case. But I do think, to your point, Charles, about experts, it provides some really important objective evidence they can use when experts disagree, which is a big problem we see a lot in the US, you know, with Blurred Lines or Katy Perry, whatever. You can always find some expert who's, you can pay them to say that these 2 melodies are identical, and then the other side finds an expert that says they're completely different. So if we can give some numbers to kind of provide some more context, I think it'll help make these a bit fairer in the US and hopefully around the world.
Are you using musical information or sonic information? Or,
well, certainly I think sonic information contains musical information, but we can break down the sonic information into, you know, melody, rhythm, timbre, and other things like, you know, instrumentation, kind of like timbre. And we do break it down into those dimensions. In particular, our algorithm focuses mainly on pitch. It kind of ignores rhythm more or less, and ignores all these things like whether it's sung or on a guitar or on a, you know, a digital thing. And so just the melodic pitch sequence information actually performs quite well. In fact, it performs better than automated methods that try to account for timbre and things like that, which is good because at least in the US and many of these jurisdictions, it shouldn't matter what instrument you're playing on. It should matter if it's the same melody or not. And so far we find that focusing on the melody does help.
Yeah, that's interesting. I mean, I think that the issue of the preeminence of melody will probably come up at several other points in the discussion later today, particularly. I certainly wanted to ask you, Patton, be interested in commenting on this, is the potential of searchable collections of purely musical information, like incipits, of melodic incipits, in adjudicating infringement disputes. Databases to identify what we refer to as terminology used in patent law, but in very much is an issue, and increasingly so, according to a couple of the participants in the U.S. panel a little later on, that that these databases are increasingly or have the potential increasingly to be of existing material that may or may not be in the public domain. Pat, does your work have any overlap with those technologies? And well, not just Pat, but with any of you, what do you think of the potential for these growing electronic musical information that can be publicly searched in dispositions of music infringement disputes?
So maybe since you did point to me, but also others, I did just talk a little bit, so maybe I'll answer quickly, and then I'd love to hear people's thoughts from your other perspective. But I would just sort of say, yes, these algorithms have value. We've shown they have some predictive success. They can make things more objective, but we need to be aware that there's always a dark side to these algorithms, and there's I think it's Goodhart's law. So whenever a measure becomes a target, it ceases to be a useful measure. So this 50% cutoff that I suggested, if it becomes, widely established as a thing, people are going to start to game the system, and they'll say, well, if we just tweak the melody this much, so it's on this side of the cutoff, then we'll be safe from the algorithms. You also get things like effectively p-hacking. So if you troll through all the melodies that have ever been created, you're always going to be able to find something that's pretty similar. So I think there's a danger of these technologies being weaponized. So we need to balance that, and we decide that the positives of having objective things with the sort of the negatives of those being exploited.
Mm-hmm.
But I'd love to hear if people are dealing with these issues in your own countries or your practices.
Yeah, other thoughts on these databases, but general music analytic technologies in predicting and potential similarity in infringement disputes.
Yeah, I think that's a very important point I would like to add. It's about a database, because I think it's pretty important to clarify the scope. What is the scope of copyright protection? Actually, in Chinese music market, we don't have the registration system now. So sometimes in the court, it's pretty hard to know what kind of evidence we should base on, because we don't file any sound recording or file any, document. We don't have any documents, maybe musical score or maybe the sound recording in the database. So I think the US also face the same problem, the same problem in Chinese music market, because when we try to decide the degree of substantial similarity, it's pretty hard, because now it's pretty hard to know what is the scope. Yeah, for example, in the Marvin Gaye case, it's pretty, some scholar maybe think in the future we need to register the copyright when someone finished their creation. Stable, we can really figure out what's the scope. So I think maybe in the future in the Chinese market, maybe we can build some kind of database, or maybe the registration system is quite important for us.
It's interesting, yeah, because as you know, of course, there's no registration requirement to obtain copyright in the US. And yet I had never really thought of the registrations as being a potential resource for whether your work is too close. Now, of course, you could do a search, I guess, in the Copyright Office to see who has registered what. But is your suggestion that if China were to implement a required registration that might be beneficial, and in terms of avoiding liability?
Yeah, based on some journal articles, I know some scholars think this is a very good way we can deal with some very tough music infringement cases. But I think the problem now is how can we really, where's the money? Because I think in the US, maybe Escape and BMI has very good database about the licensing. But I think in the Chinese music market, should we let the government to do the database, or maybe we just let the music collecting society to do that? Because they also have that kind of ability to do that. And maybe the database can be very sufficient because they have more information. Because the recording label maybe have more correct information than the government. Governments should spend a lot of money, a lot of time to try to, figure out the correct ownership information. So I think the real problem is here. And who should pay for the database? Should the government, raise some kind of fund to support this kind of database? Yeah, a very tricky question. But I think in the Chinese music market, we have that kind of potential to build a very sufficient licensing or maybe copyright protection database. Yeah, in the near future. Yeah.
Or advocate for a required registration?
I think, yeah, some people think maybe this is not good, but from my perspective, I think it's good. Yeah, but some people maybe think this is some kind of, we will limit the free speech maybe a little bit if you try to, put a registration. We try to, put back the registration system. Because actually in Taiwan, I think maybe 50 years ago, we have a registration system actually. But we abandoned the system because we try to follow the international treaties. Yeah, but now I think the problem we face is about an international treaty. It seems some kind of convention, avoid us try to do this kind of amendment in our local copyright law. So yeah, I think we need more research and try to, find a new approach and try to overcome this kind of issue. But I think the US can be a very good model for us because I read some journal articles, some scholars think maybe registration system is good. Yeah.
Interesting. Okay. Thank you, Jesse. I want to turn to you, Subhash, if I may, because you brought up an interesting when we had an earlier discussion about India and music copyright litigation, and that is when most of us think of think of Bollywood, and you mentioned that Bollywood's just one fraction of a larger industry, and that most Westerners are completely ignorant of other areas. And I wondered if you could talk a little bit about the Indian music market and also genres that are unfamiliar to us and copyright issues specifically associated with them. When we think of Bollywood litigation, it's very similar to Western content. But I think you intimated that there were other musical genres, or areas that most of us are simply unaware of it. And I wondered if you could talk a little bit about that.
Yes. Well, I'm sure we are not unaware. We are just ignorant that India, has so many languages, so many dialects, so many different communities, and it's a very interesting mix of culture. And as Indian Constitution itself has mentioned that there are 22 official languages. So it's not just Hindi or English. There are 22 official languages of India. So you can imagine the the culture and the the diversification of different languages have led to creation of interesting and very big music industry, very big creative industries. So there are industries from the northern India, say Punjab region, or towards eastern India, which is Bengal. Then there are a lot of music companies from South India. There are so many movies coming out of South India. In fact, it will be very interesting to point out here that a lot of landmark judgments relates to these regional music composers or companies. There are cases which primarily deal with use of folk music, use of regional music in Bollywood, and how they have sort of replicated, or they have used regional music, folk music in Bollywood without giving credit. So there are a lot of cases around direct infringement of copyright exclusive rights as well as special moral rights. And especially in cases of folk music, so you would get to know about so many folk artists who have performed certain folk songs in certain manner, and these songs have been copied, and they have been just picked up by the Bollywood music producers, music composers, and later when they become more popular and they are more broadcasted across the globe, then these regional musicians, music composers, artists, they get to know about their music, and then they start disputing the rights. So there is a lot of change happening because of the technology. Now there's a lot of accessibility across India. Initially it was more focused or more concentrated towards cities like Mumbai or Delhi or Bangalore, but now across India you have accessibility in terms of internet, in terms of OTTs, in terms of music apps. So there is a lot of information which is available. So it's very difficult to now pick up regional music, folk music, and bring it to Bollywood and just publish it as a Bollywood music. Probably you would have heard of A.R. Rahman. He is one of the stalwart music composer who comes from South Indian industry. There's a landmark judgment of Ilayaraja, who is also a stalwart music composer. He also lyricist. He also comes from South India. In fact, it's again very interesting that Bollywood only comprises of say about 35 to 40% of Indian music industry. The remaining 60 odd percent is from regional music, and that includes Punjabi music, that includes Bengali music, the South Indian music, and they form a very substantial part of the pool, the creative pool that we have in India in terms of music.
Can I quickly interject with a question? Subhash, so in these disputes, who is the claimant? If it's a traditional work, if it's something that's been known for hundreds of years, perhaps.
Yeah, it's in public domain. Yeah.
Who I don't quite. Of course, if it's a contemporary composer, but my impression is what you're talking about. It's in many cases, it's part of. It's just part of the region. So is it how are these disputes framed? Are they framed as cultural appropriation? Is it who is the claimant? And
so largely I would just bifurcate into two aspects. One is regional music, which is still not in public domain, and one is which is folk art or folk music. So what we have seen in case of regional music, that there is direct infringement, and there is definitely how we define different sort of works which are protected under copyright law. So you have original musical work, and then you also have sound recording, you also have cinematographic film. So they all are the derivative works and the original works, they all are protected independently. So when it comes to regional music, if it is proprietary music, if it is proprietary lyrics or musical composition or sound recording, then whoever is the owner is the claimant. In case of folk music specifically, I've seen cases where largely it is how it is performed. So they say, for example, there is a lyrics of a song which is very popular in Rajasthan or in Punjab or in Bengal. How the performer has performed, because at times it's just the lyrics may have been performed in a specific manner. Now you make it as an R&B or a hip hop or a rock song. In that case, how it has been performed, what is the sound, what is the musical composition used? Now, if that is being copied, then the music composer becomes the claimant. And yes, both your exclusive right as well as your moral rights, both are cause of action in such cases.
But this is in the case of a living and active composer who
Yes.
say there is a folk tune from several hundred years ago, and it's now been used as the basis of a jazz composition or an R&B or whatever. Are there cases involving claims against Bollywood by?
No, not as such, because if you have heard of Coke Studio for matter, there is one program which is sponsored by Coke Studio. So they generally perform public domain work.
Mm-hmm.
And so they would rather use the lyrics or musical composition of these folk music, Sufi songs and all these songs, and they will mix it, blend it with modern instruments. They will put keys and percussions on it. So not generally that there are cultural, say, NGOs or societies or associations of a community which is representing where there could be a copyright infringement. Also, because it's very interesting, the Indian copyright law, it only grants right in respect to whatever is protected under that law. So say Indian copyright law protects exclusive rights of owners, it has broadcasters' right, it has rights for, moral rights, but does not have right as of cultural appropriation, as you mentioned,
Mm-hmm.
So probably that is one of the reasons why there are no copyright infringement or copyright violation cases or cases coming out of Copyright Act. But there could be cases of, say, disparagement of public, nuisance, or could be of that.
In which case it would be a community that's the complainant?
Yes, it should be the community. Yes.
Okay. And Subhash, there's a question that came in for you, and that is it simply says it sounds as though there are rights in the cover version.
There are rights in the cover version. So, well, it's a very interesting thing. In 2012, there was an amendment in the Copyright Act, and what was considered as an exception, the cover versions, they are now brought out of the copyright exceptions, just like fair use in the US, and they have been made as a statutory licensing provision. So now, if somebody makes a cover version, because India is a developing country, they wanted people to use others' music to promote themselves. So and a lot of good star performers and star composers, they have they got popularized because of the cover versions. So cover version used to be an exception. It was considered as a fair deal, as a fair dealing provision. But now after 2012, you have to take statutory license to even create a cover version. So when you are making a cover version where you're not making any changes, you're not doing a remixing, you are just using the original music, original lyrics, original sound recording, creating your own work, then you also have to take a license which will be on a nominal fee, but you still can avail that license. So you don't have to just assume that it's an exception to the copyright infringement.
Mm-hmm.
Does it answer?
Yeah, it did for me, and I hope for the request.
So yes, it's not a right, but it's a permission which is granted under law.
Okay. And there were a couple of other. One, I think this is a question, Pat, that might you might be most comfortable answering, and that is, how is algorithmic comparison different from a visual comparison of the music notation?
Thanks. Yeah, that's a great question. In many ways, it's not. It's actually very similar to the really old school method that the judge learned hands made, just visually comparing things and counting the number of notes that are the same. The main difference is that our method is automated, so you can do it at larger scale, and you don't have to make necessarily subjective judgments about which notes should match. You can add those judgments. You can correct the automated thing to as necessary, but the basic algorithm is kind of automated. Now, our algorithm is pretty basic. In fact, that's kind of one of its strengths because it's quite simple. It's just basically this visual method, but kind of formalized and quantified. So I hope it would be useful for, presenting to juries or judges. There are other algorithms out there, and one of them was shared in the chat, which was published by one of our collaborators who collaborated with me and Charles on some of these analyses. And that's more complicated, and what it does is it weights similarity based on how common certain things are in a large corpus. So that's has its strengths and weaknesses. The strength is that then it's more likely to correctly identify if a pattern is similar but not very original, like say the Katy Perry, like it's a very basic common ostinato. And if you look at the example file that was shared through the chat, I apply this method just to show you the visuals. You can count that it's 75% identical, but correctly kind of threw out the jury verdict and said, yes, they're very similar, but it's just not substantial similarity. It's not original enough. It's too common. And so if you have an algorithm that weights by commonness, then that makes it kind of more nuanced and sophisticated than just visual comparison, just note counting. You can also imagine many different other kinds of algorithms. You could apply deep learning algorithms that will just train it based on large databases and maybe get perhaps potentially more nuanced kinds of weighting of similarity. But again, it's only going to be as good as the data and the metrics, and there's always going to be some, I think, possibility for bias or kind of deceiving ourselves that the algorithms are more meaningful than they are.
Thanks. And Subhash, if I can follow up, we have another question I think that might be related to the previous one, and that is the license to make a cover required even if you are not making a profit? I assume this means in
yes,
India.
that is a requirement. Yes, because there are different licenses. You have statutory license for when you're making profit, when you're broadcasting. So even for cover version, there is a license required. And
this is a broader question. On a global scale, for whomever would be willing to address this, on a global scale, the author from one country may not receive any financial damages from infringement in another country because of different ways market. How to deal with this question mark?
I couldn't hear the question properly. I'm so sorry.
Can you see the question under question and answer? The author from one country may not receive financial damages from different ways of distribution and market. Or something we might come back to. Because I did want to raise a very broad question that's been on my mind as I've been thinking about our get together, and that is whether you feel that copyright, or your thoughts on whether copyright is relevant primarily or only to Western musical idioms. Any thoughts on that? How is it? Is it very much a Western? Does it very much accommodate, or can it only accommodate Western musical traditions?
Maybe I just have a very short answer. I think Patrick is an expert on this issue. I think for the traditional Chinese music, there are so many pentatonic scales, like the blues scale in the Western music. So because there are just 5 notes in this kind of scale. So I think sometimes if you don't depend on the tempo, and different kind of punch, or maybe different kind of factor to decide to clarify the substantial similarity. I think for the Chinese traditional Chinese music, it's more easy to jump in the scope of music infringements. because it's more the just 5 notes. So for the Western music, because they are trying to use a chromatic scale, and they are more, you know how to use more the different notes, and the chromatic notes to do the improvisation, something like that. So I think for the protection of traditional Chinese music, maybe we need some kind of different kind of standard. You know, we need to, think about the culture. You know, the culture is different, and maybe I think, for example, in the court, you need to hire a very good expert, really know traditional Chinese music, so you can get more good information. Yeah.
Pat, you mentioned that you were traditional Japanese, I guess, folk songs, and presumably there's original compositions in using Japanese music techniques, genres. And do you have any thoughts on this? What about in Japan? Or does copyright accommodate musical genres?
Yeah, it's a really good question. So I completely agree that the laws and the cases should be, based on knowledge of the specific system, especially if it's like a traditional genre that may follow different principles from, say, these kind of global Western-based kind of pop cases that kind of take most of the money and the focus. At the same time, music is quite universal in many ways. The pentatonic scale that's very common in traditional Chinese music is also very common in many other kinds of music. And as Jesse mentioned, most pop music is also basically pentatonic. They basically use 5 notes of the blues scale, maybe 1 or 2, kind of for color. But 5 notes, you're going to get 20% similarity if it's all just kind of completely random and chance. And yet, with only those 5 notes, we make so many, diverse and beautiful and interesting different things. And in Japan actually, Japanese folk songs are also mainly pentatonic. They use slightly different versions of the pentatonic scales, but the principles are pretty similar. So there are some pretty strong constraints that do make music quite similar in many ways across many cultures. And I think because of those constraints, some of these methods, like these algorithms, can be applied quite well in a sort of cross-cultural way. They can work in different contexts in ways that maybe trying to do lyric-based things might not, because language is just, I think, vary more than music's across cultures. But I completely agree that the specifics of any given case should take into account what is the details of that tradition. And there may certainly be cases where what is considered, completely original in a certain Chinese tradition might be considered completely, identical somewhere else, or vice versa. So it is tricky, but I do think that music is universal enough, and these scales and melodies are universal enough that there is, I think, quite a bit of potential for sort of not 100% universal, but universal-ish kinds of methods that can be applied to different jurisdictions, maybe productively, I would hope.
Mm-hmm. Yeah, no, I'm reminded of some years ago, there was a complete production of the Chinese opera, the Peony Pavilion, very famous, to most of the performances, and I realized as I was hearing it that there were inflections that I simply wasn't comprehending. I could hear them, but I couldn't make sense of them. It didn't, and I was thinking, well, copyright would protect in a certain culture, or not for me, because I subtleties, but maybe the same is true for Indian music with ragas. If you can identify a particular raga and recognize an interesting combination, let's say, of ragas in a work, maybe that is something that I couldn't, comprehend that or appreciate that the same way as someone versed in that tradition could. And yet that's not protected, a really protectable expression, because ragas are more of a component that can be combined in many ways by anybody. And yet maybe that's not true. Anyway, I will. I want to get back to a couple of other questions that have come in. One for you, Subhash, and that is, if melodies from classical Indian music are incorporated into a modern music track, what is the scope for protection? So it's kind of derived from a public domain work.
Yeah, well, it depends. Now, as Professor Cronin, you also mentioned that ragas. So ragas are different. They are very standard notations or standard way of playing a music. It would largely, the infringement again would largely depend upon whether that work has been performed in certain manner, and say a rag can be performed in different ways. It can have different compositions, right? So what is being used in the modern music, if it is something which is performed by, say, Pandit Ravi Shankar or someone who has recently passed away, he had performed that that particular piece which is supposed to be a cultural rag. If that is something which is proprietary, which is copyright subject matter, definitely there is a cause of action. But if it is a plain simple use of, say, folk music, there are so many folk music in India, then probably it will be difficult to protect under the Copyright Act as such. Yeah, I think it's very important to analyze, and probably where I see a lot of use of database, like which can assess and analyze if certain music is a folk music which is already in public domain. I don't think, I've not come across a library which identifies folk music and say this is a folk music, it is in public domain, it can be used by anyone, right? So that probably is I would rather not agree with Patrick here to say that it's a hand of infringers, but rather something which can facilitate to understand what cannot or what will not amount to infringement. So you can use that music, create your own piece, and that can itself be a copyright subject matter. So yeah, I think you can continue and use as much folk music as you can and make some good music out of it.
Thank you. I think we are out of time, Bob. If there is anything anybody would like to add before we move on to the next panel, I would be very eager to hear it. Anything in particular?
So hi, I actually have a short comment for your question about the Chinese opera. So there are very limited cases involving Chinese opera in China, but there are some. So of course, China copyright law would protect the Chinese opera, but the difficult thing is the creation of Chinese opera is quite different from the Western music. Like the vocal inflection you mentioned from the Chinese opera, in Chinese court, they actually affirm that the vocal inflection is created by the singer instead of the composer. And it is created by the singer based on their understanding of the story, the music, and even adopt the singer's voice characteristics.
So and improvise. They improvise. It's not. This is something on the spur of the moment. You could only capture it in a recording then.
Sorry. Yeah, can I just add a quick comment? I think Lily was saying that it's kind of a school or style established by art troupe, organization or something, and also incorporates what Charles comments, improvisation not captured in recording. At least two scenarios here. Yeah.
So in this little less, want to cover topics such as music copyright infringement analysis, the framework for and application of that analysis, the role of experts, and perhaps the potential role of databases and computer to discuss in the first panel. Protection for sampling in particular, which of course in Europe and Germany would be covered as a neighboring right of a sound recording rather than copyright per se. We want to talk about use of songs by political campaigns and the degree to which composers and recording artists can challenge those uses. We want to talk about something called the publication right and editorial rights in the EU, something that is unknown here in the United States. And then a number of issues concerning enforcement and liability. Website blocking injunctions when they are a relatively new voluntary agreement between internet access providers and right holders in Germany, and then the implementation of Article 17 of the EU DSM copyright directive on liability of users and upload platforms. So I welcome questions in the chat, and I'm going to make sure that I have my Q&A window open here on the side. So please ask if you have a question. I won't guarantee that we'll be able to fit them all in, but we will try. So I'd like to start with a comparative sketch of how copyright infringement cases, although this is panel through a series of circumstances, we have a German-heavy panel, which is a good thing. And Jonathan Huber, one of the panelists, wrote a master's thesis on German music copyright infringement cases from 1966 to 2020, so a 55-year period or so. A paper on that, two supervisors of his thesis, one of whom the basic statistics, I think, during that time are that you found 17 cases that include published opinions concerning musical infringement during that time. The courts found infringement in 4 of those cases. They found found no infringement in 9 of those cases. And apparently another of the 4 cases, a court finding on infringement. There may have been other intermediate opinions, but there was no final judgment as to infringement in those other 4 cases. That, of course, is a relatively small sample size compared to copyright infringement resource from the United States. I think there are over 200 cases during that same from the US, about 12 times as many. Nonetheless, we've got these 17 cases, and I think that they are enough that we can develop a kind of common doctrinal structure, put together itself, so that we can discuss the framework of music copyright infringement analysis in Germany. And Daniel, have I guess just anything to add or to correct about my sort of overview of the thesis and then the paper that will be published?
No, I think that's it's a very good introduction. Thanks very much, Bob. I think that covers the most important aspects. It is true that Jonathan was only able to find 17 cases in these 50 years, but that is the entirety. It's not a sample, it's the whole population of cases that seem to have been decided during that year. And that is telling in itself, right? If you compare that to the US. So it clearly tells us something about where money flows in copyright and where you sue if you can. But this is just occurred to me. But I think it's once we look at the charts that Jonathan has prepared, I think a lot of things will become clearer.
So yes, okay. So in statistical terms, in some ways, maybe it is a population and not a sample. I appreciate that. I assume, I guess just let me ask one clarifying question. I assume that it does not necessarily cover all cases in which complaints were filed, but the cases were settled before there was any published opinion. Martin Schaefer is going to have something to say about that.
Yes, indeed. Because as a practitioner in this field, that's indeed true, Bob. I think a large number of cases that might have been on top of the ones that have been published would have been those that were settled or dealt with in any other way out of court. I suppose in my own practice, I've seen that to happen rather often, and usually parties are eager to not disclose what they have come. What kind of settlement they reached, and unlike the US and Germany, the court registers are not public. You cannot get access to court files if the decisions are not published by the court or by the parties.
Yeah, and that's an important bit of additional background to keep in mind and perhaps add to during this discussion, that in the US we are used to having open dockets. Anything that's filed with a court is available to the public, which would include all pleadings and would also include expert opinions once they are filed with the court. I found out during sort of the dialogue in preparation for this panel that you can't get access to the expert opinions, for example, because they aren't published. They are not available, and so that may have sort of an impact on our understanding of these cases. Now, the court's published opinion, and if they are, you can see them. You can see them in the published opinion, but the experts' opinions themselves are not published. So if I can ask Adam, so apparently we've set that we can't display slides like you would on Zoom, where it sort of obscures the faces of the panelists, but we can put a slides that Jonathan and Daniel prepared in the chat. And if I can ask you to do that so that audience members who would like to can use a visual aid as well, that would be helpful. This useful chart has 4 different stages considering a copyright musical infringement case, right? And the first stage is to identify the sequence within a plaintiff has complained, and then ask about the copyright status of that part of, or that sequence within the musical work, right? Is it creative enough to be protected by copyright? By copyright, is it of minimal creativity so that it would be quite thinly protected? First, that's stage number 1. Stage number 2 is doing the substantial, the plaintiff's work as sort of narrowed and filtered to the defendant's work, and coming to a conclusion as to whether they're substantial similar. 3 is asking the question about whether the defendant has independently created their work, or has in fact either copying in fact or independent creation. And then stage 4 is asking this question about whether an exception to liability would apply. For 2021, we had a separate paragraph that talked about freie Benutzung, or free use. Since then, the concept, if it is of freie Benutzung, has been transferred in different language to Article 23, and we have explicit acknowledgement for prestige and parody and quotation in pages of outline. I think it'd be useful to pages 1 and 2, which I think are perhaps conceptually the trickiest. So perhaps we've got here on the panel who might want to say something about, I guess, start with stage 1. What is it? What does it mean to examine the plaintiff's work and the particular sequence that the plaintiff claimed to do a copyrightability or copyright thinness and thickness analysis of that sequence?
I think I can start here. I hope I got everything correct, Bob, because I have some audio breakdown, or your audio has some small breakdowns. I don't know if this is a technical issue at my point, but I hope I got it correctly. I maybe start with step 1. One short disclaimer: I'm not a lawyer. I did this analysis from a musicology perspective. So and Daniel is also a musicologist. So we focused on this musicology approach, not on the legal details. This is important to know, I think. But as you said, I do mainly agree the step 1 and 2 are maybe the most complex and I think the most interesting ones from this musical perspective, because it is a lot about how music works, how the different parts of features within the music interact with each other, and the question, is it even possible to distinguish between melody and harmony and rhythm, for example? Because this is what in some cases is done. There is a question, well, is the melody copyrighted, or is the rhythm of the song copyrighted? Is harmony copyrighted? And in interaction with step 2, I think this is the central question of, is the interaction between these features copyrighted? That's what in Germany is called, or what German courts call Gesamteindruck, kind of an overall impression. And this appeared to be the most important musical feature, if you want to call it like this, to check whether it is copyrighted or not. We have examples in this analysis where the melody itself is not copyrighted because it's too simple. It's like a common thing that cannot be owned in a copyright way. But the usage of this melody in the context of the song is copyrighted, and then this is the answer of to step 1, and the answer in the context of step 2 is this overall impression between the two songs similar enough that this is a case of copyright infringement, or is it only the melody that is the same, but the melody itself is not copyrighted, so it would be no copyright infringement?
Excellent. Just sort of thinking next about, step 1. The first step is to think about the part of the work that the plaintiff says has been infringed, and to sort of analyze its whether it meets the threshold of copyrightability at all, and even if it does, how thick is that copyright protection? Do other panelists, Daniel or Martin, have comments to make about that that part of the analysis?
Well, I can only subscribe to everything Jonathan has just said. I've had a case where this played a role rather recently with a kind of overkill in experts. I think it was 4 altogether, 2 on either side, and the whole thing was really very, very special. And those were exactly the issues that were discussed. And we had the benefit of a court that was very knowledgeable in music. And I think this is where infringement cases are finally decided, whether or not you find a court that has a sufficient degree of expertise to even understand what the experts are talking about. I have to say that while those discussions were going on, I was completely lost. And I think this is one of the essential, but by the way, this is also a case that will never appear in any public context, even though it was gigantic. And the parties were very well known. And yes, but I think to support that, there is the methodology, the methods that musicology applies are used in exactly that way, and then those poor guys on the legal side have to deal with this.
Yeah, maybe just to add that it is indeed an interesting musicological question. What is an element that is trivial and so commonplace that all musicians, at least all musicians within one style, would know about it and would use it in their own daily work? So typically these elements would then be considered not to be copyrightable because it's part of the musical language, right? So you can't own a scale going up or down or any trivial bass figures, for example. But then it's very unclear where this threshold lies, where you go from a trivial element to a combination of maybe elements that are trivial all by itself, but then put together, several motives put together, form a melody, and this becomes a new thing, a gestalt, or something alive, a characteristic on its own. So this is something that, is appealing to musicology question, and it obviously has to do with the length of the excerpt. So a single note can't be copyrightable, 2 notes can't be copyrightable, that's just an interval. But the longer the sequence gets, the more degrees of freedom and creative and artistic choices you can make. And the likelihood that a copyrightable melody comes out of that is just higher if you have more steps in a sequence to choose from. But it's usually, so in practice, it's usually decided by in expert witness reports or opinions that decide one way or another, or argue one way or another, whether an individual element is copyrightable or is commonplace. And one way to substantiate these claims or provide some evidence is to look back into music history and see whether you can find exactly this melody or this musical object being used in other musical works before. If that's the case and that's been used frequently in the past, then this suggests it's commonplace. If it's hard to find, then that might suggest it's more likely that this is actually original and can earn a copyright on its own. And this is where technology now becomes very valuable. Now that larger databases of music in different formats are available, you don't have to rely on the finite memory of a music expert, but you can actually search, use a computer to search large databases and provide evidence whether certain melodic phrases. So this is, I think, where we're getting into a new age where technology and databases and the transcription of music and different renditions of music that are available now can help to decide and provide some objective evidence in some cases, at least.
of course, one does wonder whether, as the databases get larger and larger, whether a number that sounds high may actually be quite low, which is to say, if you've got, 1 million works in your database and you say, aha, this exact 7-note melody has been used 17 times, 17, is that a large number, or is that not such a large number over the past of music? Then we would get into arguments about, well, let's look at each of the 17 uses and how widely distributed was that piece of music and so on. So I can imagine the argument could sort of continue apace.
Absolutely, and it then becomes a very interesting psychological argument, right? So what, as a creative and performing musician, are you able to remember? What would influence your creative processes if you're writing a new song or a new piece? And even if you don't find a trivial motive, it might not mean that it's copyrightable just by that fact. So I'm not sure whether you heard that, but there was this Ed Sheeran case that's been dealt with in London a couple of days ago. And it was about a very small motive that Ed Sheeran claimed is very trivial. And his expert witness said, had to admit he wasn't able to find that in any prior existing songs, but still would maintain that it's a trivial motive. So the fact that you can't find that motive does not automatically mean that it's copyrighted. It could still be trivial.
Another thing that occurs to me is that with published opinions, that's being made through a series of filters that have excluded other kinds of cases before they get to the published opinion, right? And one of those filters, for example, is how much is this case worth? Certain threshold, it will be less likely to lead to the kind of litigation that would lead to a published opinion, right? That litigation costs money, and you may not be investing that money without a certain right jurisprudence. Is just that we're talking about cases that are probably that are not very certainly infringement, right? If we're talking about a copying of a 50-note sequence, then probably that's never going to get to a published opinion on substantial similarity, because that's sort of taken as a given. So the opinion pushing the boundaries we can. That's why we're seeing these opinions about 7 notes and 10 notes and things like that. Let me ask about the substantial similarity second step, and I guess the first question I want to ask is about the theoretical framework in which substantial similarity would be approached, right? So there's a famous framework that in US law can probably be traced back at least to a case called Arnstein, in which a judge by the name of Jerome Frank says that, look, the whole point of copyright is to protect the market value of music. Depends upon the perception of the audience that is paying directly or indirectly for that music. If we're talking about popular music, then we're talking about not an audience of musical experts. We're talking about whoever is listening to that music. And so what we want to ask when we're asking about whether an ordinary listener of that type of music, who has whatever kind of musical cognition that an ordinary listener has and whatever kind of musical knowledge that an ordinary listener has, would perceive messages from the plaintiff and the defendant as closely enough that their aesthetic appeal is the same, and therefore they might serve as substitutes, which would lead to the market harm. That you might just listen to the defendants because it sounds close enough to the plaintiffs that why play the plaintiff's price, right? So I guess I want to ask whether in European and German jurisprudence, is there a similar framework which would kind of ground the inquiry into substantial similarity? Because I feel like without that grounding, we're kind of left swimming as to what counts as substantial or not. Any of the panelists want to? Eleanor.
Can I say something here?
Sure.
Yeah, I think that I really like Jonathan's work a lot, and I've known Daniel for years and years, and I know his work well, and I think they're both on the right track, and I really like the detail in the German. The nature of cases in the U.S. and Germany doesn't have nearly as many complaints filed as the U.S. does. The trend line in U.S. cases with smaller and smaller amounts of music in them in the focus of the trial just doesn't make any sense to me at all. So I'm always trying to figure out where did this problem start. So what is substantial? I'm in favor of both quantitative and qualitative measures of that. And I think Daniel's background in psychology is very informative here. I think to answer your question, Bob, substantial, yeah, I will get, I suppose I talk about basis later, but the measures are much more that you have to read music, you don't have to play an instrument, you don't have to do anything to form musical memories and to contextualize things. They're human nature. But I think what I like about the German approach is that it's much better articulated. It's much more clearer. It seems to me, in most of the judgments I read at the MCIR, the quantitative side of things is just more and more ignored. If somebody, any person at all under the sun sees a vague resemblance between 4 notes of this and 4 notes of that, then they jump on it right away. But to me, and this also refers to Jonathan's chart, the weighting of these different features really matters a lot, and the ways in which melody and rhythm are combined. Because you can, as Bob, we've been discussing this in correspondence earlier, you can change the rhythm of a certain sequence of tones and nobody will recognize it. Because we relate very strongly to pitch elements, but small children, if you watch small children responding to music, rhythm is the thing that hooks them. Small children can't usually carry tunes terribly well. So they may know, say, oh, I know that, I've heard that before, let me sing that for you, and you won't recognize it if their pitch is terribly unfocused. But if you get them to clap, it's completely unambiguous. The segregation of the features that you talked about a few minutes ago, how do you integrate into one picture? These are very complicated questions with endless possibilities for exploration. And I think we should all be aware of them. But deal with them in a simple, easily communicated format is really very difficult. So I look forward to learning a lot more from all of you about different views of substantial similarity. But in the first instance, there has to be something quantitative that's much more substantial. And I can throw out a few numbers if we talk separately about databases.
Okay, thank you. Others on substantial similarity in German law, and I guess particularly in the, is there some reference to Martin? Is there some reference to the kind of the underlying goal of this analysis and how it would frame what we're doing?
Was that the question to Daniel or to me? Because I just wanted to add that there is one area that has been developing throughout the last 10 or 15 years with the issues we are discussing here, and the substantial similarity is almost necessarily tested in all those aspects: rhythm, the instruments used. You can even do without, as you just said, Eleanor, you can even do without the melody if the similarity in the other areas is strong enough. The case that I was referring to, for instance, was a sound-alike that was done to make the audience believe it was a song they all knew, and it was used for an advert. And the reason for doing that was that the super large company that made use of this easy way to get music into their advert, they just didn't want to spend the advertisement sync fees that would have been very considerable. So they got themselves a shortcut to a very similar result by commissioning something that sounded to the broad public exactly like this, even though they avoided to take the melody. And it was astonishing to see the feedback from the audience on the social media, because they all recognized it. They all asked, it's kind of slightly different, but why did the artist give consent to using it in this context? I can't imagine why he should have done it. And the point really was, and I think there's an industry developing to do exactly that. At least in Germany, it's still a nuisance to write sources in the original pieces, and I would say throughout Europe at least. And so they are kind of trying to find that little path between substantial similarity that would make it illegal and recognizability in a sense that everyone will know what is referred to, and in a considerable part of the audience will create the impression that it is indeed the original. And that is something that I found very striking, especially in the way how we had to deal with this in this lawsuit, because there you get access to the two totally different ways of thinking. The one way of thinking is about how can I avoid substantial similarity purposely to get my thing on the legal side, and the other side saying basically as long as I recognize it to be what it is meant to stand for, it must be substantially similar. So we eventually were on that side, and the court held that it was the case, but exactly the type of discussions we had where it was a very thin line, and it was not at all a safe thing for us to say that we could win this. And I suppose that's the same everywhere in the US and everywhere else, because there are people specialized on doing this. It's not only the artists who take in influences from various sources. There are people who deliberately do this.
No, I appreciate that comment. It's a very interesting example, and that I think can bring us to this question of whether melody somehow has a special role to play. Out in your research that out of the 17 cases, up to 10 different aspects of a musical work, that the most commonly mentioned was melody. And it is also the case, which was 16 in the 17, by the way. And I guess just for comparative purposes, rhythm was mentioned in 14, and this Gesamteindruck or overall impression was measured in 10. It was mentioned in 10 of the cases. You could be asking why is melody dominant in the cases, and then we could be asking as well, why does melody seem to achieve special mention legally? Because both in the old Article 24 of the Copyright Act, in which melody is singled out, the only singling out, as an exception to freie Benutzung, and in the new Article 23, which melody is explicitly singled out as for adaptations, especially melody. That's an interesting question. I mean, especially in light of Martin's most recent example, which suggests that you could, if you wanted to, avoid melodic copying, but if you copied everything else, the rhythm, the timbre, the tempo, you would give everybody the impression that it's the same work. So I know that was a lot of questions rolled up into one. Maybe we could start just with the question of why we think that melody has been dominant in the decided cases. Any thoughts on that?
It's obvious that rules in different places prioritize some of these issues about music very differently, and I'm reading some interesting comments in the chat here too. I think that for me, when I look at the whole general situation of music copyright, I'm very struck, because I do live in California, that we have, over the last 10 years, the percentage of all cases that have been argued involving musical similarity have depended entirely on sound capture of some sort. And an awful lot of the musical features that are actually discussed have nothing to do with the old principles of melody, harmony, and rhythm, for a start, which come from the world of notated music, but they come from passive listeners, and sometimes active musicians too, who sort of compose on the fly and don't necessarily read music themselves, and want to steer around the hard evidence, which I think notation is. So I've noticed this, what I see over and over and over again is what people are actually arguing about is often timbral qualities. This is the case in Stairway to Heaven. At least to my ear, those four notes that have been argued over so much, which have an ancient history, it's the timbral similarity that's striking, but the actual musical details are entirely different. And the problem with this privileging of timbre and tempo and dynamics is that they, when you privilege those, you're privileging a performance of a piece of music, but you're not actually talking about the music itself, because the music itself, you can also abstract those sound qualities and apply them to something else, and probably you won't think they're the same unless there's a close correspondence between the rhythmic structure and the pitch structure and so forth. But I just I find this a constant obstacle in trying to compare cases, compare opinions between something that is only known through a sounds reproduction and something that has a notated framework somewhere. So that's probably a little to the side of your point, but I think it does bear when you start to talk about what are people listening, whether they're active participants in musical life or whether they're passive listeners, which you know, earphones and so forth have made lots and lots of our students in that category. There are a whole lot of very general but very thorny issues there, and it's another whole world to parse the way Jonathan has parsed the steps in determining infringement. So I think ultimately it will be important. I should yield the floor to the next person, though.
Yeah, I mean, I guess I want to return to the question. I understand that it may well be that in some recent cases that played a much larger role because sound recordings now make possible repeated identical experiences of timbre, which we didn't have before we had recorded music. What we had was identical, were in fact the notes, not the performance. But it does seem to be that in these German cases, and frankly, I think in a lot of the US cases as well, that melody is singled out. And a lot of attention is paid to melody. If there are more comments about the sense historically in these cases. Any thoughts from the other panelists? Daniel, did you?
Well, I can only speculate, but I think there are some historical reasons why melody is special. So in traditional composer training, you do have treatises and very clear instructions, for example, how to harmonize a piece of music in different ways, or how to use instrumentation. And those some time ago were considered what you should have learned as a composer. So these advices and the different ways that you could treat harmony or instrumentation could not be original and copyrightable music or produce that very infrequently because the rules were known, laid out. But there are fewer treatises on how to compose melody out there. And melody seems to have more degrees of freedom. So it's probably more likely that you compose something with melody that is copyrightable and that hasn't a complete precedent there. But the question is whether that's still applicable and whether this historical view has still its right in a time where you say sounds are very easy to copy. Actually, they come from sound libraries, and often, or in a lot of music, sound and rhythm and texture plays an important role. So there's a whole genre of music that does without music. If you think about rap music that might not have any melody at all, and still you would consider these works of music, right? So we certainly need to move beyond that. And it just occurs to me that Joseph Fishman, who's I think on the later panel, also has written a great article some years ago where he says this is a fiction that melody has some primary privilege in music copyright, but it has been a very useful fiction over the past, because this is one of the ways where you can actually decide by musical analysis what is substantially similar and what isn't similar. So even though we might not believe in that this privilege of melody is justified, we might still use it in actual proceedings.
Okay, well, I appreciate that. I mean, one of the questions, though, then would be if we continue to privilege melody because, for example, it's relatively easy to compare one melody to another, then are we starting to slide away from any connection to what once we thought was the justification for this, namely that this was how the to be lured from one piece to another, right? I mean, if the original idea of substantial similarity is, well, what we're worried about is that the listener is not going to buy the plaintiff's, not going to listen to the plaintiff's music anymore because the defendant's music is good enough. Then if we continue to but it turns out, as perhaps partly as Eleanor is suggesting, that melody is perhaps becoming less central than maybe the rationale and the analysis are kind of are drifting apart. I do think, however, that another reason for the centrality of melody is that popular music is, in particular, is not harmonically complex or daring, nor is it likely to be polyphonic, right? We're four equal voices interweaving in a popular music piece. We are likely to have an emphasis on the singer in the front. It is often in popular music, it is the singer's musical content. And so with the emphasis on that single front person, perhaps there has at least historically been more melody-centered pieces than in other genres of music. Any other comments specifically on the substantial similarity analysis? Leonie, did substantial similarity?
So I think most of what I thought has already been said. Maybe what might be interesting, especially to just touch upon, is the explanatory memorandum for the new 23 of the German Copyright Act, because in that it actually says that the strict melody protection that was formally codified in Section 24 of the Copyright Act has been struck out, because usually when a melody is recognizable, it will be a copyright infringement. At least this is what the legislator said in his explanation, and I thought this might be an interesting point of view from a legal perspective to add to this discussion of substantial similarity. So it seems that, especially with melodies, when one it's more likely than maybe in other cases that it's an infringement, that it's not a kind of free use that the Copyright Act.
That and that the German legislator has actually seen fit to make explicit the continuation of or melody. It's it's an interesting question about why is that done. A musical cognition justification that, well, because it turns out that in most cases, or in some substantial percentage of cases, it is the melody that is important to listeners. A more cynical kind of lobbying explanation that, well, somebody got into that room and started arguing that they wanted their melodies protected, and the legislators took note of that request. Any other thoughts from the other panelists on why it might be that the legislature has been across a large sweep of time interested in mentioning melody specifically in the German Copyright Act?
I would like to add another point to the question before, because we have talked a lot about the music perception perspective now, but I want to add the perspective from the other side, from the composition, because it appears as these copyright cases are mainly about how does the audience perceive the different works. Does the audience mention that there is a similarity? Is there maybe like this process Martin just described, that something is composed to sound like another piece because I don't want to pay the sync fee or something? But I think this substantial similarity idea has also something to do with how the composition process works, because I think the idea is important that if composers try to compose something, they are always influenced by things they know, by things that are commonly known in music. And I think the question is it possible that two people come to the same idea to express maybe the same the same thing? For example, if two people want to write a sad song, maybe they just have the same idea how to express it, and that's why there are some similarities between the two songs. This is very hard to prove, of course, but I think it's also an interesting point to discuss, because it is not always about I want to sound like somebody else, and that's why I take something from him and make it a bit different so that nobody will mention afterwards. But it can also be the other path of simply having the same idea.
Okay, well, but if I was trying to put those two together, maybe it's that. So you're talking about now the third step of analysis in the four that we outlined before, the question of whether two musical works have been independently created or not, and maybe that and this also goes back to what Daniel was saying, that maybe it's the case that at least a sufficiently long melody of a sufficiently large number of pitches is less likely to have been independently created, or something like that. And that's why we would place a special protection on melody, because we think it would have been copied if it showed up in a second work.
I think, of course, the longer the melody is, the more likely it appears to be that it is stolen if it's the same. If this was understandable.
All other things being equal.
But I think it is not only a part of step 3, but also part of the step 2 and the question of substantial similarities. If substantial means that it is kind of if I have the idea, nobody else will have the chance to have this idea on his or her own.
Mm-hmm. Well, so maybe then we should go on to talk about experts, but you're right that we've been talking about sort of audience perception now and maybe that's traceable back to the idea of a market analysis, but of course, European copyright law and German copyright law is said often not to be focused entirely on the protection of the personality of the creator. And so, although it may not have been perfectly articulated, maybe part of what's going on is the idea that if somebody's musical work is more creative along some scale that has yet to be, agreed upon, should grant that additional protection is more like have some market impact or another, but merely because another end of copyright law is to protect creativity. We would like to protect that especially creative process that's been going through, the result, I guess, as well, that's been going on. Okay, so experts. So just going back to sort of the 17 cases you found. In those 17 cases, and this is available on one of the pages, the slides that there's a link to. In the 17 cases, 12 of them, whereas 5 of them that were aligned with one of the parties, or perhaps both of the parties, different experts. So I'm wondering if one of you could explain how the use of German courts, and in this context in particular, and why in some cases you might have just party-aligned experts who are according to professional advocating in the best interest of their clients, and some of them have independent experts that are supposed to be giving an independent assessment to the court. Martin, you're still muted. Martin, you're still muted. Martin, you are. I think I'm not sure whether you can hear me. So we're not hearing you. Well, okay. Well, perhaps for the moment, if you unmute himself, maybe Daniel, maybe you could step in for a moment and
yeah. So in a typical case, each party would solicit an expert witness report just to reassure themselves that they're on the right track and that they can actually win this case or get royalties or defend their position against the plaintiff. And party expert reports can be submitted to court as evidence if this case actually gets to court. And the judges then can look at these expert opinions, and if the court is knowledgeable, it might actually be convincing enough for them to just base their judgment on this. But if the case is more complex, the German courts can also solicit an independent expert witness who would usually be given access to the individual party opinions, and then the independent expert can kind of find a balanced judgment or explain why positions might be conflicting and suggest a position that the court could then follow. And I believe in most cases courts would follow the independent expert's advice or ideas, but I think it's in the minority of cases that independent expert witness reports are actually solicited. Often this would actually make the case much longer, and in many cases it might not be necessary because the facts are trivial, or the judges are knowledgeable enough about music to form their own opinion.
Okay. You mentioned in conversation or an email exchange that there are actually an astonishingly music copyright experts who regularly appear in these cases and discussed from the U.S. perspective on the U.S. panel as well. So do you want to say a little bit about the circle of?
Well, this is really just from informal observations, and would be interesting to hear whether Martin agrees with that. But so from knowing the scene a little bit, I think there might be about 5 or 6 people in Germany who make most of their living from expert witness reports and who get contacted by lawyers, publishers, agencies a lot, especially at the pre-trial stage. They would then write a short expert witness report, a couple of pages, saying you've got some grounds to pursue this case, or you better drop this at this stage because you're in a bad position. And apart from these 5 or 6 people who do this on a regular basis, there's a larger circle of people, including me and some others, my colleague Klaus Frieler, for example, who get contacted maybe on an irregular basis, a few times a year, to give an additional opinion if these regular experts aren't available, or they have a conflict of interest, or for some reason they couldn't be trusted with a particular case. Yeah, independent experts' witness reports solicited by courts, I think that's a fairly rare thing. So there are very few cases where this actually happens. And I happen to be an expert witness report on one of the stages of the Metall of Metall case, where I wasn't given access to the individual party experts' opinions, but had to find my way to answer this question, whether actually the sample was underlying the infringing work or not. But maybe Martin knows from his daily practice how many people there are that you can actually write to who would provide a good expert witness opinion.
Well, I would subscribe to what you just said to 100%. It's just that reflects my own experience. It's a relatively small circle of experts. I hope you hear me now.
Yes.
Yeah, that are doing this, and yes, even though there is a federal Court of Justice case law saying that a court, unless very qualified in musicology and able to assess the usually more than one expert opinions that are introduced by either party, it is just as Daniel said. It's relatively. There's no singular case that pops up to my mind where really a court would have commissioned yet another expert opinion, so yes, that's what I meant earlier. That you rely on a court that is educated enough in music to find its way through the experts' opinions that are lying in front of them. They usually know the principal musicologists doing those kinds of opinions, and you can either regard that to be a deficit. I try to bring in new people from time to time, and that works pretty well. But to get established in that scene, you need to be recommended, and so I think that's pretty much the experience you made, and so you end up in a very prominent case because you haven't been involved in all those daily in those daily business opinions, but that's what is exactly my own experience in those fields. But the reason why I originally, it's not any longer quite in the flow, but last word about melody, when fate struck and cut me off my microphone. One of the things that came to my mind when I heard your discussion, I mean, this is a very, very ancient part of copyright law. So it was in the copyright law of 1901 already. And I assume at that time, when there was no recorded music at all, there were basically two types of exploitation that relied heavily on melody. One was the predecessor of the sound recording that was inserted in those how do you call them? Yes. And those were not always really orchestrated. So it was the melody line. You have still those little small ones that are really doing nothing more but to reproduce a melody. And I suppose the same applies to much of the use that was made in private homes. The kind of sheet music was not an orchestrated one, but it was the small everyday music was very much very much melody orientated, and people played it on their piano at home. And I suppose that the extreme emphasis put on melody was in that context, but that's just a guess. I don't know. I don't know whether it's nonsense or whether that could have some truth in it. But one has to know that the notion of melody is extremely old in copyright law.
Mm-hmm. Well, it's very interesting that like the mention of melody in German copyright law dates back to 1901. That's really interesting. Let me go on and talk about sampling, which of course involves sound recordings, not notated music. And the key case in Germany is Metall auf Metall, and that it's an investigation that involves many opinions, but I think for our purposes, the most important part is probably the ECJ opinion that came out, and perhaps one of you could just say a little bit about this. Involves sampling by the two German rappers, Moses Pelham and Sabrina Settler, Kraftwerk piece called Metall auf Metall, hence the name. So what does the ECJ say about sampling, and how the analysis would be the same as or different than a music case involving copyright?
Whom do you want to say something about that?
I was asking for any volunteer.
You know, everyone shies away from this monumental task, because this is, I mean, really it's a singular thing. It has been this case has been going on for over 2 decades, almost 3 now. It was 4 times at the Federal Court of Justice, was once at the Constitutional Court, which is the supreme equivalent to the US Supreme Court, then the European Court of Justice, and it's about to go up to the Federal Court of Justice once again, the 5th time. So whoever even attempts to put all the things you want to know in a nutshell is necessarily doomed to fail.
No,
I'll try it anyway.
I mean, I guess one of the things that seems interesting to me, and partly it's a U.S. perspective, is that the ECJ says that there's no de minimis exception for sampling, which would distinguish that from musical copyright. And that discussion, the U.S. case of Bridgeport, which is a Sixth Circuit case, is actually cited. But the sequence is that Bridgeport is decided, then the ECJ Metall auf Metall. So later in the Ninth Circuit in VMG versus Salsol, the Ninth Circuit says, "Oh no, that's not right. There should be a diminished, there shouldn't be any different analysis of this respect than So there should be a de minimis exception here. So that's one aspect of the opinion that I think is interesting. Perhaps one of the reasons why there's no Article 24 now in German copyright law that specifically uses the term freie Benutzung is that I believe that the ECJ also cast doubt on freie Benutzung in German law. So maybe
yes, absolutely. Yeah, so you're absolutely right. Well, the point is really that there are now to address those three issues that you put on the table. The first, indeed, this is about sound sampling in sound recordings. It's not a work that they're talking about. So due to the totally different concept of the protection of sound recordings, that is not following at all the creative approach that is laid down in the Berne Union and everywhere in the traditional European thinking of copyright, but the investment in a sound recording. And due to the totally different protected matter, the idea has always been, as long as you take something from this protected matter, you make use of it irrespective of how short it is. That was always the assumption. And then the question came into play, and that's one of the aspects of this game, but that can certainly not be without limit. And then the second point came into play, saying, is it a reproduction if you don't even notice it's being used? So there's this issue of recognizability, which is, to me, should be no criterion, but rather, if I don't recognize that a certain fragment is being used, I simply won't be able to sue. So except for technical analysis of a sound recording, maybe you can get a fragment from a sound recording that makes it identifiable. But generally speaking, the cases that come to court are always such where, even though it's a very, very short segment that wouldn't qualify for copyright protection in the authorship copyright concept, would be under protection once it's recognizable, and that was clearly the case with this very, very short piece from Metall auf Metall, but that was looped throughout the song that was in dispute. So the question that then came to the court was a very, how shall I say, technical one, and this was about when Article 20 was Section 24 of the German Copyright Act was finally cut back and eventually deleted after the German courts had started to transform it into a statutory limitation, which was never meant to be. It was just, as it is today, merely a further explanation of what the adaptation rules want to say. They wanted to draw a borderline if it is beyond the limits of the protected subject matter, then you can use it freely. So it wasn't meant it was never meant to be an exception. It was just trying to put in words, and the mistake might have been that it wasn't part of this Section 23 in the first place. Mm-hmm. That you have to regard that as a sliding scale. So you have the clear-cut adaptation where something is clearly used and still visible to do something new, and then you have things that fade out to a degree that it's nothing more than an inspiration. So this is what the background is. But what the court said was very, very technical. They said there had been a time back in the late 1990s when we discussed the copyright directive that eventually was passed in 2001. And at that time, we created a comprehensive and exclusive catalog of exceptions and limitations that are admissible throughout the European Union. And if an exception or limitation is not listed there, you cannot make use of it. And if you invent an exception that is now phrased to be a free use exception, show me where it is in the list. And then it said that the court said, look, you wouldn't find it there. It's not there. So please remove it from your law and try again. So and that's what they did eventually. I mean, the point is that that the issue that we are all dealing with is something that has not to do with exceptions and limitations. It's about a totally different thing. It's about the inspiration versus making use of a creation.
Okay. That makes sense now, and now I'm getting a much better picture of why in the discussion. What's left of freie Benutzung is this sort of second sentence that explains the flip side of the adaptation right.
Yes, exactly.
Yeah. Let me talk about protection against use of songs by political campaigns for a little bit, Leonie, perhaps you could say just a couple of words about cases in which folks who no longer own the economic rights perhaps still are able to object to the use of their songs in political contexts.
Yes, so you just touched upon the economic rights, which are often transferred where Jonathan is. So in those cases where songs were used by political parties, that comes from 2018. And essentially what happened is that the SPD, that was declared unconstitutional by the German Constitutional Court, used the song. They paid their given, but in the end, the court declared that this because they were associated with the political party by use of the song during the campaign. And so essentially the smart right is protected somehow. So there is Section 11, Section 14 in the Copyright Act, but more importantly, it's a constitution. So it's part of the general right to personality that this moral right derives from in Germany. So even though a composer might transfer their economic rights to the song to begin with, they still that is simply not transferable. And the question always is there an infringement? So the author is simply not transferable. So what the court will do in the end is interest of the and the interest of the composer. So in this case, the who. And what they decided here is that that then could simply not right political party to use their song during an electoral campaign. So in essence, they also did not transfer that economic rights, not license the party to use that song. So I hope that's made it clear for the broad scope of what right is under German law.
Yeah, no, I appreciate that explanation very much. I guess I just have two quick follow-ups. One is when you talked about the court kind of weighing both sides of things, that sounds quite context dependent. So one might imagine that if were just as background music before an event started, let's say, that it would be the use of a song, while the principal candidate for the party was walking out on stage, so I wonder if that context is taken into account. And then the second aspect of it is, okay, so this was the NPD, which is as you said, a party that was declared to be sort of anti-constitutional. Would it be different if the same band, as to the same kind of use by the CDU, for example, a much more traditional, that just said, I don't want to be associated with the CDU. I just not interested. Do we think that the reaction of the court would be the same as to when it was the NPD, which, as the court said, something that we understand why you wouldn't want to be associated with?
To touch upon the first thing you just asked, circumstances are important. Yes, they're very important to this weighing up that I just mentioned. So in the case, use the song just when they to potential actors, and that was crucial to the decision of the federal court. They did not just use it as background music, just playing by the way. So yes, that to the decision in the end, and to if use that song. It really depends on the whether question is it's so connected right personality that Constitution under Article 1. So they brought a claim against the CDU, as you just mentioned. It's really hard to say, but it might have been different. This was definitely a crucial factor in the NPD decision that declared anti-constitutional before, but it's not the sole factor. So it really depends on the sector, and it depends on how the band before. So, for example, they clearly a party that wants to be associated with the far left, for example, party like the CDU. Maybe you could that you have cases in that area.
Well, yes, I had a case like this one against a far right-wing party, and we have made similar experiences. In fact, this whole concept is, as Leonie just outlined, is a very special case. Generally speaking, this has it boils down to the issue that normally, I don't know how it's in the US, but as far as I can recall, the publisher would be able to steer the type of use, even in public performance, mostly, at least in certain contexts. And I would be interested to hear if that's the case. But the reason why I'm mentioning it, there's a famous case
Thank you. Let me just. I think we have one more. If I can ask your 2 more minutes. I just want to say a little bit about. Publication rights, because I think this is an area that US and possibly Asian audiences really are not familiar with. The US used to have kind of a copyright system that was entirely based on publication, but we've now switched to a system that's entirely based on life of the author, or in some approximation of that. But in Europe, you now have a system where copyright that's life of the. You've got the possibility of getting rights on older works that have never been published if you publish them for the first time. And this is the term of that has been standardized to 25 years after publication. And this has actually been litigated a number of times. So this is not a provision. This is a provision that has bite, especially in the area of classical music, where the works themselves may be hundreds of years old. So, Eleanor, if you could just say a couple of words about the litigated cases, maybe particularly involving Lionel Sawkins, that would give the audience some exposure to a that we're not familiar with.
Right, sure. Yeah, I've spent more time in the UK and Italy than in Germany, but I interact with a lot of Germans in some of the projects I work on. And yeah, I guess I'm here to say that in classical music, there are also big sums occasionally dispersed. And in one big case in the UK, it had to do with editorial rights. But what I'm struck by in listening to all of you is that we're talking more along the lines that Martin just was, in the sense that where things often get complicated is not in the editing of the music or the publishing of the music, but the rights that flow on from there in recordings, in performance, in films, and so forth. Because classical music seems to have a very long lifetime. And there are, of course, many hundreds of thousands of works, if not millions, that exist. And editors, this varies a lot from country to country, though. In Germany, and in large measure in Italy and in France, editors are well treated, they're well supported, and the whole network for reviving music, for finding scores, for editing them, for consigning rights to publishers, to libraries. Everybody expects to be rewarded. The libraries that hold the source, and on and on and on. So a very large settlement in the UK a little over 15 years ago did involve a situation where an expert editor with a deep knowledge, lifetime knowledge of French music, had edited works that he intended for publication, but they're very bulky, the chorus, orchestra, voices, solo voices, and that can be translated to lots of pages and so forth. And the company in the UK he was working with refused to pay him for his contribution and refused to acknowledge that he was an editor, and just thought that the way the UK law was written was stupid, and he was set to change it. And so the publisher would just was set to have a case, really, to precipitate the case. And I think in the end, the courts didn't like that very much. And so there was a very big judgment against him. And what they ended up saying, well, they said his moral rights were violated because he was not acknowledged in the recording, and he was not acknowledged in any of the subsidiary rights that the publisher then bestowed on other people. But also that he had done so much work, and that was very well documented especially in the appeals, by having the best expert you could possibly get in the UK at the time. It was Stanley Sadie.
I want to start by inviting you to walk us through. This is a music copyright infringement case, and you have had an amazing set of cases that have come before you over the years, both at the district court as well as the Second Circuit. So walk us through how you approach these music copyright infringement cases, whether there's a difference between these cases, how you approach those cases at the district court level and the Second Circuit appeal level.
Thank you, and thank you for inviting me to participate in this conference. I don't know that I approach music copyright infringement cases differently from other cases. There certainly is a different approach as between the trial court and the circuit court. Of course, at the circuit level, everything comes to you done. The record is hopefully complete, and you look back at what was done. In the district court, of course, you're helping to make the record, and so to that extent, it is very different. You know, to the extent that there will be is likely to be an expert witness in the music cases, that is something to take into account. But otherwise, I think the approach is the same as any case. You know, you want to be well prepared. You want to anticipate what the issues are. You want to, you know, try to tee up the motions in limine. You want to let the lawyers try their cases, but at the same time, you want to maintain control and move things along. You want to give the parties a fair shot. And I can get into some more details as we go along. But you know, I have had a fair number of music cases, both more so in the trial court, less so in the circuit.
Thanks, Judge Chen. So Hugh Hansen, who both of us know, likes to use this analogy of district court judges being in the trenches and courts at the appeals level being sort of at the command center. And being a district court judge, you would have access to looking at witnesses, musicologists, parties, the musicians even. Whereas at the appeals court level, it's in a sense much more insulated, and your role is mostly looking at for errors of law. And how does that shape how you might understand a case or how you might decide a case?
Yeah, well, I mean, I think you're absolutely right. The role at the circuit level is very limited. We've got to be concerned about the standards of review, and on some things, it's abuse of discretion. And you know, I certainly am respectful of the district court's decisions. But at the trial level, you know, you are very much involved. If the case does go to trial, you know, simple things like what is the verdict sheet going to look like? And what are the claims that we are going to put to the jury? I remember my first patent trial, and the parties wanted to put like 25 claims to the jury. And part of what I did, perhaps not knowing better, was to simplify it and boil it down to, you know, 4 or 5 claims. And to that extent, you know, at the trial level, you're not just an umpire. You know, you are really helping to shape the issues. You've got to worry about making your record so that when it does go up, there will be a proper record. You know, I was going back and looking at my music cases. In the circuit court, I believe I've only had one music copyright infringement. And it really wasn't even about infringement. It was the consent decree, BMI, ASCAP case, and was the setting of fees. But in the trial court, I mean, for example, I had one of the first peer-to-peer file copying cases some 20 years ago. It's not even something we think about anymore, peer-to-peer filing. But I remember when it first came out, it was a big issue. But I've had cases involving Russian classical music, Indian music, Hootie and the Blowfish, Mariah Carey, country western songs, Michael Bolton, and others. And they've always been a lot of fun. Most of my music infringement cases involve lyrics and not so much the music. And I think with lyrics, you're less likely to need an expert. I did have one case that involved some music and lyrics, and there we had expert testimony, but I decided it on affidavit. One of the interesting things I found in reading the cases in preparation for today is how often cases go to trial in the Ninth Circuit, and how often there are reversals in the Ninth Circuit. The Led Zeppelin case, there was a trial when there probably shouldn't have been one. Katy Perry, there was a trial when there probably shouldn't have been one. And now Taylor Swift, there will be a trial when perhaps there shouldn't be one. So I have actually never tried a music case because they are usually resolved on motion. I did have two hearings. One involved a preliminary injunction hearing to enjoin the distribution of those Russian CDs, the CDs of Russian music. And then in the Mariah Carey case, I had a very interesting hearing, but it was really because I thought fraud was being committed on the court. It was not because of any of the infringement issues.
Great. And this, by the way, is a great way to plug the Second Circuit. So if you're thinking of filing a case, go to Judge Chin's court.
I'm struck that there are so few music cases. I mean, I guess all the artists are in California, but we certainly get our share of copyright cases, but it seems not as many music cases for some.
I actually want to ask Peter and Bob at this point. I mean, you guys think about venue, I'm sure, all the time. And I think, Peter, when you dealt with the Led Zeppelin case, you had that transfer from Pennsylvania to California. So what went through your mind in thinking, okay, we should have this case heard in this court or this circuit rather than another one?
A quick Westlaw search to realize that there's basically no published music standard in the circuit in which Pennsylvania sits. I mean, basically, the judge was wonderful and they were, it was a great venue, but, they just don't have established music copyright law. The Ninth Circuit, on the other hand, of course, does. And so it was a pretty easy choice. And we also had witnesses and parties who were in California. I think the real issue is whether we went to New York or to California, and we ended up opting for California. But it was really
why not New York?
Why not New York? Why not New York?
Exactly.
It was something that Your Honor, that Judge Chin pointed out, is there's just not that much law at the Court of Appeal level in the Second Circuit, and we had some good law, at least some good suggestions on the law on deposit copies, and also we have in the Ninth Circuit the extrinsic test. Now, in the Second Circuit, you have the advantage that the judge can decide basically whether they sound alike, but in the Ninth Circuit, you have this ability to go in with a analytical dissection of the music through musicologists, and we felt very confident that would err on our side because the only similarity in the music was a descending chromatic scale, which isn't protected. And so, it was a dangerous case because to lay people, both songs have descending chromatic scale, both songs were played on a guitar, recorded in the studio, so they had a lot of performance elements that were similar. So it was dangerous in that sense. But the ability, and you could have a judge say, well, it sounds similar to me, but you had the ability in the Ninth Circuit to actually have an expert dissect it, point out that the similarity is a scale. And so that is really what tilted it in favor of the Ninth Circuit.
Thanks, Peter. Bob?
Well, I would echo that. I think it really depends on how strong musicology reports are. And if you think you can win the case on the musicology report, the Ninth Circuit is a better place to be because they will do that more readily, I think.
Now, that's a follow-up question, which I'm going to ask to all three of you, but also the rest of the panel if you want to weigh in. Who does the best job at determining copyright infringement, substantial similarity in particular? The judge, the jury, or musicologists?
I defer to Professor Chin to start that one, but I have a view.
Judge Chen, why don't you start us off?
Yeah, I mean, I think I've never had a trial. I've always felt comfortable doing these things. If you're trying to figure out whether a reasonable jury could find substantial similarity, I mean, there usually is dispute as to the lyrics. There's no dispute as to the notes, what the notes are in these cases. And so I think a judge in most cases will be able to do it. It is very helpful to have assistance from the musicologist. I am not an expert in music. I actually have a law clerk who majored in music. She was also a singer, and she explained to me that music is like a language, and a musicologist serves as an interpreter. But to the extent the musicologist can simplify things and make things understandable, that's very helpful for me. It would be very helpful for a jury. But I think, most of these cases can be decided by the court.
Thanks, Chen. Peter?
Yeah, I was just going to say, during the course of the Led Zeppelin case and discovery, I asked everyone. I asked, after depositions, court reporters and videographers, which do you think there's a similarity here? And without exception, people who had no music background thought, yeah, that's substantially similar. And people who had a music background said, no, that's a chromatic scale with some extra notes that are different. And so there's always that problem. And if you look at, for example, the Katy Perry case, where it was just, 4 notes in a row followed by 2 notes, and which appears in prior music, and the jury found liability. So, all jury trials, of course, are risky. But and I think that what Judge Chien said about it's a language and you need an interpreter, I think that's crucial, because most people, our grandparents or, people who came to the US made their kids learn music, but nowadays, a lot of people don't understand music. They can't read music. So they need the expert to walk them through it. And sometimes they just get confused. In the Blurred Lines case, where the plaintiff, the gay family's expert testified there wasn't a single note that was similar. And I know the lawyers on both sides, and they were talking to the jurors afterwards, and they said, yeah, we couldn't understand any of the music. We just, all the experts just canceled each other out. So I think my answer to it is you need the translator, you need the musicologist, but ultimately you need a judge who pays attention to it, comes up to speed on that little bit of music, and can make a right decision.
I think the other issue is separating out protectable from unprotectable. I think the jury might have a harder time. It sounds similar, and the jury is less worried about separating out what's protectable from what's not protectable. And a judge, I think, is better equipped to do that.
Can I chime in on this as well, Daryl?
Yeah, Joe, go ahead.
So I agree with basically everything that Judge Chien and Peter just said. I want to add to it to tie this back to what Peter was saying before about the predictability of at least knowing that in the Ninth Circuit there's an extrinsic test. You get an additional layer of predictability when you have judges deciding cases on dispositive motions, which is they will tell you, if I'm dismissing this case, here's exactly why. If I'm not dismissing this case, here's exactly why. So it's less of a black box than a jury verdict is going to be. And I think, it's only to the benefit of musicians if we at least, whatever courts are going to do, that they provide some guidelines as to here's what's okay and here's what's not okay. And I think you get a lot more of that when judges are the ones deciding the cases with the help of the musicological interpreters.
Yeah, I think, one thing that never changes, no matter how old we are, whether we are a 3-year-old that, just got spanked, or whether we are 30 or 60, we want to know why, right? Why is this happening? And certainly judges do that. Now, the flip side to that, however, is I think a point which you and Cristelia made in your article, which this is a sneak preview. We're not quite getting to that yet, but I think it is connected to it. And that is, it's very easy for somebody applying the extrinsic-intrinsic test or the whatever variation across different circuits to deconstruct everything so that nothing is original and nothing is copyrightable. So how do you advise judges having to make this decision, make this call? Now that you're saying we want judges and because they give the decisions, how do you advise them to find the right balance? What guideline would you recommend they use? Joe or anyone else?
Well, I mean, I can tell you, first of all, I hear that a lot. You know, when we move for summary judgment, we point out that there are these commonplace musical building blocks, and the other side says, well, you're just dissecting it to the point, you know, that kind of thing. And that usually is in the context of a selection and arrangement claim, where there's, you know, saying, yes, it's just one note or two notes here and a chord progression, but it all appears with it. And I think I've found, without exception, that judges are sensitive to the issue, but they don't take it to the extreme. It's not like, well, you know, Gone with the Wind is just a selection and arrangement of the letters in the alphabet. They actually do understand, you know, and they see a line, as vague as it might be, between analyzing the work and identifying constituent elements that aren't protected versus going to the point of saying, well, that's an eighth note, you can't protect an eighth note, even though it's in a, you know, 15-note melody that's exactly the same. You know, judges are, I think, are pretty good at sniffing that out and striking that balance. And I think Skidmore actually helps also on the selection and arrangement by pointing out they have to cohere into a musical work. You know, that you can't just have random similarities. And I think that also avoids the issue of someone coming in and saying, well, on either side, and saying there's similarity or difference because there's a note here and a fade ending there, you know, and something else. There is a point, you know, and it gets back to something that was said earlier about you have to protect composers. You know, they have to be able to use musical elements that everyone has used for, you know, years and decades and sometimes centuries. And so you've got to be able to point out these are, you know, musical building blocks, and there just has to be this balance between identifying those versus dissecting a work to the point of you're just talking about notes rather than melody.
Yeah, thanks, Peter. I think that's a great insight, and one which is at the heart of patent law right now. This idea of how do you prevent something from over monopolizing and yet at the same time protecting what should be protected. Cristelia, Rob, do you have any thoughts on what's been said so far?
I would add, well, first, thank you for having me here and to everyone for this wonderful conversation. I would add that I share some of the concern Daryl outlined, right, that, you know, anytime you are relying upon someone with more knowledge than the person they're speaking to analyze the thing, there's the potential for manipulation. And Joe and I mentioned an example of one of our forensic musicologist interviewees who expressed that sort of, but, you know, sometimes it gets taken apart to the point that, you know, and I do think that Peter's explanation goes quite some way. The other thing that gives me some comfort there, of course, is that there are typically experts on both sides, right? So to the extent that you do have someone perhaps engaging in over splicing of elements, I feel comforted to some extent by the fact that there's typically an expert on the other side, at least making the case to the judge that there has been a bit of excessive over splicing in this case, and that gives the judge sort of a more complete view of the field. And like Peter, I think that for the most part, they're able to see the forest for the trees and understand that we are looking at a collection of elements in most cases, at least in these cases that rely upon arrangement.
So you trust the judges then?
I try to.
Okay.
Can I add something that may be a surprise to some people is in almost every instance, and I've had a lot of these cases, the musicologists agree. Their transcriptions are the same. There'll be some instances where they'll say, well, this could be, you know, a flat rather than a sharp or something like that. But they generally agree. But you get into this situation of once they've agreed as to what the transcriptions are, you know, then where do you go from there? And does it appear in prior art? Is it commonplace? And it cuts both ways. I had a case for the weekend that was affirmed by the Ninth Circuit, where the experts agreed on the transcriptions, And the plaintiff's expert said, that's all right, and that all appears in prior art, but there's one note in each of 3 measures in different melody. And those are the 3 most important notes. And the court just said, come on, you gotta be kidding. I mean, they're not even in sequence. They're set in different, melodies. So you have this dissection issue on both sides, where sometimes a plaintiff, because they're musicologists, is analyzing it and coming up with the same conclusion, as an interpreter. You end up with the plaintiff basically having to pick and choose different things to try and find a similarity and dissecting that to the point of just a single note in the whole measure.
Thanks, Peter. I'm going to ask Rob if he wants to weigh in, and then I'm going to take a question from the audience. Rob?
Yeah, I just wanted to weigh in. I should start with saying that I am speaking in my personal capacity and not on behalf of the office, but just wanted to weigh in on a couple of comments that Judge Chien made and also to Peter, that I do agree that, in terms of the legal nuance, the nuanced legal issues that are very difficult for juries to face, that judges are often in a better position to be able to differentiate between some of those nuances, and it's very difficult to capture all the complexity and interrelationship of copyright law in jury instructions and that manner. So in that respect, I think often the court is in a better position. But also following up on what Peter said, after in teaching copyright law for 29 years now, I've been struck by the difference between those students who have had a musical background and those who don't. That exactly what Peter said, that those who do have a musical background are often have a very different view of infringement and of the building blocks of musical composition than do those without, who may be more influenced by just common total concept and feel kind of assessments of the similarities between 2 works. And I think that's the struggle in the 2 parts, either the probative similarity and the improper appropriation phase, or the extrinsic and intrinsic test, is in that dissection and finding what is or is not copyrightable, the elements within a musical composition, then having to come back and putting that together in terms of the selection arrangement is a hard conceptual leap to make. It's easy to begin to conflate those concepts and to be considering, although the elements, uncopyrightable elements, may be selected and arranged in a original and creative manner, it's often that sometimes seems to be, it's that original selection arrangement that is protectable, not just any selection and arrangement that is similar between 2 works.
Thanks, and I think that was at the heart of the Taylor Swift case, which we'll get to afterwards. But I'm going to take a question from the audience. The question is, does Your Honor or anyone else believe the establishment of an Article 1 court for copyright could be valuable beyond the new case act tribunal through the Copyright Office?
Well, I certainly don't think so. I mean, I'm being selfish. I've enjoyed the copyright cases. I didn't do any IP law before I became a judge, and since then I've had quite a few. They're terrific cases. They're fun. The lawyering is usually good, and so I would miss them. And the other thing is, one of the true joys of being a federal judge is having the variety. So I would hate to see pieces being taken away. I mean, we can manage the difficulties of certain kinds of cases, but I would be very much against creating a special court for copyright.
Plus, the Ninth Circuit is already crowding the field as it is. We really don't need more competition in that regard. What about the rest?
It's my own 2 cents is, I think our judges, I think it's good having a general background. I think our judges are good on these cases as a general rule. If you start doing that, I mean, do you make all copyright cases in front of the DC circuit or something, or like treat them as patent cases, or do you just carve out music? And people wrestle.
Well, you wouldn't be, right, Peter, because you would be basically talking about administrative tribunal. So these might be a group of experts in musicology, for example, that would listen to parties and decide as experts.
Yeah, I missed that. You're right. You did say Article 1. I would be against that. I think it should be an actual Article 3 court. I think also if you start pairing off things, then what about fabric designs? What about other copyright issues and screenplays and things that are sculptural art? Do you just throw it all into a new court? I would be against it. I would raise that in some cases a special master to determine exactly what the composition is may be appropriate. But as I said, in most instances, in all instances in my career, I believe, the musicologists, the parties musicologists have actually agreed what the transcriptions are.
So you're like juries deciding the case because they probably get it wrong, too sophisticated for them. You don't want experts deciding the case. So you think that judges are the Goldilocks? Well,
again, the judges are the ones who decide, and I think the issue with juries is, I mean, look, I won the Skidmore trial, so I have no complaint with that jury. But you get results where I think it's an issue of educating the jury, explaining it to them. In Skidmore, my expert had a piano on the witness stand and was playing things and explaining things, and we had agreed upon transcriptions, so we were able to educate them. I think if you don't go through that effort, then you have the chance of them just going by the sound of it. And I mentioned before, I believe tenor, the fact that we had 2 acoustic guitars, so they tend to sound the same. That's a compelling element. I mean, all music on bagpipes sounds the same. No one can distinguish it. And someone actually did a study, it's in a Virginia law review, where they took the music in Swirsky versus Carey, and they had it re-recorded with both songs having the same instruments, and the test jury, 80% thought it was an infringement. And then they did the exact same musical composition, but re-recorded with different instruments in each song, and 80% of the jury thought it wasn't an infringement. So you had the exact same composition, but because of tone color, the fact that the guitar sounds similar to other guitars, juries got confused. And I think it really is it's not an issue of not being decided by juries. You could have a judge go south on you if they have a tin ear, I suppose. It's really an issue of educating the judge and the jury as to what to watch out for. And that gets back to what Rob was saying, is the complexity of it. Sometimes it's just really overwhelming for people. And then you get results like blurred lines. At least that's my view.
What you have said is convincing me that it's not a bad idea to have an Article 1 court decided, because it's so complex, and because, if anything else, unlike other types of copyright claims, you have constantly this idea of having musicologists, like in patent cases where you have technical experts, and certainly you have the PTAB, and you even have the TTAB, right, at the Patent and Trademark Office. So why not an administrative tribunal for copyright cases?
The other issue, though, is we haven't talked about damages. From the plaintiff's perspective, I think you want a jury calculating the damages and not a single judge making the award, should you get that far.
Thank you.
Well, I think the real issue is that the melody of a song, as Peter's example with changing the instrumentation in the Carey case demonstrates, the melody of a song is an abstraction. People hear the totality of the record coming out of the speakers on the radio. That's the song to them. And to say, no, that's not really the song. The song is these little abstract elements of it. And you see between this record and this record, which don't sound anything alike, there's this abstract sequence of pitches and rhythms that is the same. That's a really hard thing for juries to get. And I think, it goes way back to, the earliest infringement cases talking about the lay listener standard, and it's designed for a lay audience and so on. But then it seems that the courts really kind of go out of their way not to defer to the lay listener too much, because the lay listeners get it wrong in the sense of they hear similarities that don't really count, and they don't hear similarities that do count. So I think that's really the disconnect, is that we've got this clear distinction between compositions and recordings that is not true to the experience of most jurors at all.
Right.
Thanks, Bob. I'm going to ask Judge Chien this question, and I'm going to invite the rest of you to weigh in as well. So far, we've been talking about substantial similarity, but there's, of course, another part of the copyright infringement equation, that's access. And almost without fail, whenever you have one of these celebrities being sued for infringement, Ed Sheeran or Taylor Swift, you without fail see in a news report, I've never heard this song before, right? Is that still a valid argument in an age where you have Spotify, you have YouTube, and you can really access almost anything, at least constructively?
Yeah, I think access is rarely contested. I don't know if I've had one where access was contested, and then it also does generate factual questions. So it most defendants will assume access and then proceed on substantial similarity. But I think it's a hard sell to say I've never heard it before these days, because there's virtually unfettered access.
Although, if I could add, I think that the flip side of that is that there is so much music that is available now that you could, having access to everything is virtually impossible. So it really goes back to reasonable opportunity and other specific facts about, why that particular defendant would have had access to that particular work.
In many of the cases I've had, in fact, probably most of them, access was contested because it wasn't based on the plaintiff having a released popular song. It was based on a copy given to someone who knew someone who knew someone who knew the artist. Or it was, something that was posted on YouTube, and then you bring in the statistics that there's something like, 100 billion postings on YouTube, and that gets back to what Rob was saying. You have to have a reasonable opportunity to see it. The fact that it's on the internet is not alone enough. If you start with the assumption that the plaintiff's case was in the top 10 of Billboard or something, that's definitely a harder, instance to contest access. But that's not, that happens, but most of the cases I've got are people, and I don't want to say this disparagingly, but wannabes, people who do some music, put it on some website and say, oh, they must have heard my music. And courts have been pretty good about saying, no, that's not enough. It has to be a reasonable opportunity.
Well, and that kind of goes back to the Sell versus Gibb case.
Yeah.
And, in a situation, it also brings up the issue. On the one hand, I think, what the en banc court did in Skidmore in eliminating the inverse ratio rule is wonderful, progression. But it doesn't speak to the flip side of that in terms of striking similarity. And, that is a question that comes up too, even if it didn't seem like there was a high likelihood of access, or there wasn't any evidence in Sell versus Gibb of a reasonable opportunity to view. When you do have striking similarity, and I've been involved in litigation on this, not in the music context, but in the Boucher versus Baltimore Ravens, where the defendant said, no, I did not, I never saw this before. And, but it was probably the strongest example of striking similarity I've ever seen. But we also were able to prove some reasonable opportunity for access through circumstantial evidence of access. So it really, striking similarity, I think, is another issue. And in the Sell versus Gibb, that is, when I ask people who are knowledgeable, students who are knowledgeable about music, in the situation of Sell versus Gibb, there are unusual similarities between those two works that I think do potentially have some reason for evidence of access.
Rob, for the benefit of the people on this call who don't know copyright law, can you just very simply explain this inverse ratio rule?
Sure. The inverse ratio rule was if there is a high degree of evidence of access, that you would not have to prove as much similarity between the two works. And how far you take that seems like it could go to absurd levels, because if there's no similarities between the works, then there's no copying. So even an enormous volume of access without similarity would seem to be meaningless. On the other hand, striking similarity is the inverse of the inverse ratio rule, in that where you have extraordinarily strong or unusual similarities between two works, then the need to prove a high degree of access is lessened.
Thanks. And of course, Skidmore is attributed as being the case to clarify that it doesn't apply, at least in the Ninth Circuit. Is that a good idea? Are we done with the inverse ratio rule and we never want to look at it again? What does everybody on this call think?
Yes.
Well, I'm happy.
It's good. It's a good thing that it's been trashed in the Ninth Circuit. Although I do think it really tracks the perceptions of a lay listener. I mean, or a lay juror, I should say, because if you're trying to make up your mind as a juror, did singer B copy singer A? Maybe a juror really would consider, oh well, they knew them, they played shows together and they used to sing together, and of course they knew the song. I think that would have an impact on a juror, and maybe it shouldn't, and I think it's good that the courts don't look at it that way, but I do think that's the experience of jurors would take that into consideration.
Yeah, I would add that I think one of the reasons that I'm not sad to see it go hinges on the way that the inverse ratio rule and the thinking around it perpetrated these already very different dynamics between the well-known artists and the smaller, lesser-known artists, right? Where it's much easier for a well-known artist to show access because you say, I'm Katy Perry, of course you've heard my song, right? But if you're little known band, it's going to be much more difficult. You can say, well, it's been on YouTube and it got these number of views, but you're necessarily at a disadvantage in overcoming the access hurdle anyway. And the inverse ratio rule, I think, really amped that up a bit to make it all that much. If you have lots of access because you're well known, you don't have to show very much similarity, but the inverse was true as well. Not that all the little folks are bringing colorable claims, but for those that did, this was a much higher hurdle, and I think it removes that as well.
Thanks, Cristalia. Now, Judge Chin, at the Second Circuit, where are you with the inverse ratio rule? Do you ever even have it in the first place?
I don't believe we have it. I mean, I remember reading the Ninth Circuit's decision and agreeing that it made sense to get rid of it.
Okay, thanks. Was somebody saying something?
Yeah, I just wanted to say, like, if you can imagine each of you for yourselves pick the most dissimilar two pieces of music you could possibly imagine. Right, those two pieces remain just as dissimilar one to another, whether the two composers were hanging out with each other listening to those two pieces of music, or whether they had never met each other, never heard the other song. But the mischief that the inverse ratio does is to suggest that it might actually indeed make a difference. There's absolutely no reason it should. So, I mean, that's the main reason that I'm happy to see it go.
Okay, sounds like we're one step closer to world peace. That's good. Let's move on to Skidmore. I think Skidmore raises a number of interesting issues, which we've talked about, but also dealt with the question of deposit copies. Now, Peter, tell us a bit about how the deposit copy issue came up in the case, and is that something we should be thinking about going forward?
It came up because of a ruling going back to 1908 CDs and well, albums were not considered to be copies of a work. So when the plaintiff's composition was released as a record, in a record by the group Spirit, that was not the public distribution of a copy, so it did not trigger federal copyright protection under the 1909 Act. The 1909 Act provided two ways to get copyright protection. One was the public distribution of copies with a copyright notice, and records were not were not copies of a composition embodied on the album. The other way was to actually register. And so federal copyright in the plaintiff's song in the Skidmore case, and in any song prior to the 1976 Act, was obtained by a deposit copy of a transcription of the music that copyright was claimed in. And it could be a tab form, it could be anything. The Copyright Office was pretty liberal, but you had to submit to get copyright protection, you had to submit a complete transcription, a copy of what you claim copyright in. And so the issue in Skidmore was that they claimed copyright in a deposit copy and not in the recording, because that wasn't available. So, and the recording had all these tone color issues that we were talking about before. And so we were able to convince the judge that the copyrighted work was the transcription that they deposited when they registered the work. The transcription did not have a lot of the other things. It didn't have the sound of a guitar because it was just paper. And so that's how it came up. And the Ninth Circuit has affirmed that the copyright in that circumstance is defined by the registration. Now, whether it has a broader effect under the 1976 Act is, I think, an interesting question, because then what you've got is copyright isn't triggered by the deposit of a copy, it's triggered by creation. And so the issue, I think, for deposit copies and under the current act is really one of whether the registration is valid. Because if the registration of the deposit copy in a 1976 Act registration is different from whatever they were actually had recorded, the composition in that, then you've got an issue of, well, maybe the registration is void. Although under the Supreme Court's decision last month in the Unicolors case, you'd have to show knowing falsehood, which is unlikely. So I think in going forward, there's another part of Skidmore that would be helpful, I think, in these cases, even as to 1976 Act cases, is Skidmore ruled that the district court did not abuse its discretion in refusing to allow the plaintiff to play the 1960s recording, which had all these tone color issues. And so I think in defending these going forward, I think people should think maybe they can get a motion to eliminate that prevents the playing of the deposit copy of a 1976 Act work, because it has all these other elements that are not protected, the performance elements, they're not part of the composition. And as Rob said, that can confuse the bejesus out of a jury. And so I think it had that effect, but it is a difference in that under the 1909 Act, the deposit copy defines the copyrighted work. Under the 1976 Act, creation defines it.
All right, thanks. I'm going to bring Rob in a moment, both because he had something to say about the case, but also because he is the nation's foremost expert on registration issues. He's, of course, heading the entire works at the Copyright Office. But Judge Chien, you unmuted yourself. Did you have something to say?
No, I wasn't going to add anything. I just unmuted myself. I mean, I would say it was a brilliant move on Mr. Anderson's part to move in limine, to keep out, so the jury couldn't hear the two songs being played. I think when you hear the two songs, you think, wow, they really sound alike. And so, that was good thinking and good preparation on his part.
Thank you.
Now you can something else to put on your bio, Peter.
Yes.
Rob. Yes, it is.
Cool.
Yes, it is. Which is why we couldn't play musical stuff, because we had notices from YouTube before on this. Rob?
Well, with respect to the deposit copy under the 1909 Act, I mean, Bob obviously has a lot to say about this, and his article addresses some of this as well. But under the 1909 Act, The law was that if you were registering an unpublished work, you had to provide a complete copy. The office would accept abbreviated complete copies, such as lead sheets, but that was the work that was registered for the musical composition. And at the time, that was all that could be registered, since you couldn't register a sound recording. Even under the 1976 Act, the same is true in terms of having to get a complete copy of the work. But we can probably talk about this a little more, maybe in terms of future problems for music copyright law. But one of the problems that we'll face, and I think is one of the points I would differ with Bob in terms of some of the points he was making in his article about this that he hasn't had the opportunity to explain yet. That we're dealing in the 1976 Act because of publication still plays a role, and it plays a role with respect to the deposit copy. So if before registration you have published your work, then you have to submit a best edition of the published copy. Most of the time, the first published version of the musical composition is in the sound recording. It's in the derivative sound recording is the first published version. So what now occurs more often than it did or never did under the 1909 Act is that the only thing registered is the sound recording, even for purposes of the underlying musical work. And I understand Bob's concerns about under-protecting, but there's the other concern about overprotecting when because the musical work and the sound recording are two distinct works with two distinct forms of authorship. The composition, I think one of the questions was asking in the question and answer, is under U.S. law, the musical composition cover the music and lyrics? Yes, it covers both of those, but it does not cover the performances or the production that would be part of the sound recording copyright. And going back to the blurring and confusion and complexity, that's going to be a very difficult thing for a jury to separate, particularly when that's the only thing that we may have moving forward, since we will no longer have musical compositions registered separately as they were in the Skidmore situation.
It sounds like after we have gotten rid of the inverse ratio rule, the next thing we should do is just get rid of the jury.
Daryl, I should point out, I see in the chat that someone cites a Second Circuit case. Apparently, we do have the inverse ratio rule. I wasn't sure. There's a case from 2003, but perhaps it's time for us to revisit it.
Okay, there you go. And for the audience, you heard it here first. Okay, let's move to the other case, which is the Seltzer case. And I think it brings us into a very interesting, important area of copyright infringement, which I don't think we have discussed yet, and that's fair use. And how does fair use apply in the music industry? And I'd like you to think about recent copyright cases involving Google versus Oracle or Warhol versus Goldsmith. Have these cases shifted the dial in any way with respect to where the fair use defense stands in music copyright cases?
Well, Seltzer was my case, and I should mention it didn't actually involve the music. It was a video played at the concert. And my own view quickly on Seltzer is that, it followed the Second Circuit in Carew versus Prince. And we know the Second Circuit is sort of backtracking a bit from Carew versus Prince. The Ninth Circuit last year had the Dr. Seuss case, which kind of backed off on other cases. But the thing that was, so I think there's a general sort of the pendulum swinging back a bit, with Carew being the outlier and maybe Seltzer. But Seltzer had something unique. The the plaintiff actually affirmatively testified in deposition that the defendant's work had a different message, completely different, and he didn't like it. But it was a completely different message, and it had no effect at all on his artwork. And so, I think even if the pendulum swings back, I think seltzer is still good law. But I think you're seeing a sort of retrenchment or moving away from Prince versus Carew, because that did seem to take transformation to an extreme.
Thanks, Peter. Bob, you're unmuted, so I'm going to call on you.
Oh, I'm muted? Can you hear me now?
Yes, no, you're unmuted. That's why I'm going to call on you.
Oh, okay. All right. Yes, I have just had the experience of litigating music fair use cases just under Carew and now under Warhol. And it was really like night and day. I mean, even though those cases were visual art cases, they were not music cases, it really completely changes the analysis in fair use. And I think had the Warhol decision happened a year or two earlier, there were fair use arguments that would have gone the other way. So I think very much it does change the fair use analysis, just because Carew had so much language about, just if the artist just use it as raw material, that's enough to be transformative. And it was just really, really difficult to make a good fair use analysis if the scope of transformative is so broad and so nebulous. And so I think it will make a big difference.
Thanks, Bob.
If I could just add two things. One is, and I agree completely with Robert, and there is Campbell versus Acuff Rose, which was a music case and it was a fair use, but it was parody. And so that really made it easier. The other one, and I apologize, I don't remember the case name, but I think it would involve Drake in the Southern District of New York, where he started his song with a short quote of someone, a spoken word, I think. And
that was my case.
Sorry?
That was my case. The state of Jimmy Smith against Drake. Yeah.
Yeah. Yeah. So, I don't think we see a lot of fair use cases involving music, and Robert's case was, I think, the only one that comes to mind other than the parody cases.
Thanks, Peter. I'm going to bring the academics in. Do you guys have a view on fair use in music?
I think it should be asserted more often than it is. The studies that I have seen, Ed Lee has been looking at this. It's a rarely asserted defense in music cases.
And why is that?
So, I mean, I can only conjecture, but I think, my guess, and I would be curious what the real practitioners think about this, is that given that actual copying is actually a live issue in so many of these cases, even though you could plead in the alternative, it doesn't look that great to say, I've never heard this guy, but even if I did, what I took from that song was transformative, right? Just the optics of that are bad. That's been my running theory, but I can't actually prove that.
I agree with Joe. I think that the unsettled nature, maybe unsettling is more accurate. The unsettling nature of sampling in music, right? Where it's difficult to both admit that perhaps you copied, but even if you copied, it was because you transformed it. And the other layer there, I think, why we don't see this as much in music as perhaps in other areas, like Carew or Warhol, where you're in the visual arts, but in a different format, might be because unless it's a parody or Bob's case, which was quite unique, right? Is the purpose really different, right? To the extent that transformativeness, we're looking for it to like say a different thing or have a different message, it is a little tricky, right? And super subjective. And so even if you say, Roy Orbison was actually talking about a pretty woman and we are, talking about a not so pretty woman, so they're different. It's still, unless you have parody or this particularly unique case, I think it's not your strongest argument. And all the rest is usually sampling. And so I don't think we see a lot of that. being brought either.
Thanks, Crystalia. Rob?
I would just say that I was somewhat surprised by the Seltzer reasoning, and I think that it's. I understand about testimony by witnesses often being problematic, and I think we've seen that in a number of music infringement cases, as well as with the Bolton case, where he said, "Yeah, I knew everything that was ever played." But I think it's, once again, we're in this swing of the pendulum where transformativeness is the only factor that is realistically being considered in many of the fair use decisions. And I think it's, there was this sense by the court in that case of looking at the factors as a tally sheet and going one to the other and saying which factor weighed in favor of who or slightly in favor of others. And I do have a bias in this, since I wrote an article on the second fair use factor, and which is just ordinarily dismissed in part because of Campbell, but it was dismissed in Campbell because it was not relevant in a parity situation, not in any situation that would involve an argument for transformativeness. And I think, even in the Campbell decision, it was important how far the court went in differentiating between parody versus satire, and saying that, parody, you don't need to prove these other, the amount and substantiality of the work or the effect on the market is not really relevant, and that the nature of the copyrighted work isn't relevant. But in satire, it didn't say that that wasn't capable of fair use, but that you would have to prove more. And those other factors would enter back into the analysis more. And certainly when you're outside of either parody or satire, I think what we've seen in some of these cases in terms of just looking at that single factor is really distorting, the goal of that four-factor analysis as four different perspectives of the question: is this fair?
Yeah, you bring up an interesting point, because the Supreme Court in Google versus Oracle actually didn't follow the order in which the factors were listed. I think they analyze the second factor first, and that seemed to, in that case, be the decisive factor. Is that, you think, something which we should take away from when thinking about music copyright cases?
It's interesting that not necessarily, the only time that in writing about the second factor, the only cases which begin with the second factor, besides Google, were the reverse engineering cases. Sega versus Accolade, Sony versus Connectix, those also computer software cases started with the second factor. But again, I'll give a plug for my article. There are other reasons.
Why don't you just put the link in the chat so people don't just tease us with, oh, I'm going to put a plug. Give us the link so we can actually look at it. Not right now, but afterwards.
Will do.
Okay, I'm going to take a question from the audience, and then we're going to move to Joe and Crystalia's groundbreaking research on how we seem to be moving in the direction of the dark arts in patent law. But before that, let me ask the panel this question, which has been voted up. And guys, if you want to have your question asked, please vote up the question. So I'm going to take this question here. What about using a court-appointed expert? The partisan experts, as Peter says, can cancel out, see blurred lines. So why not use the FRCP to get a court-appointed musicologist?
I referred to a special master, and that's exactly what I meant as a possibility. But in my experience, it's not really necessary, because I can't recall a single case where there was a dispute as to what the transcription looked like. Now, I think, the point's been raised that with sound recordings being the copyrighted work for the purpose of protecting the musical work, is going to get a lot more complicated. And there's going to be issues of what is a performance element, what is not, what's a compositional element. And so maybe, experts will start disagreeing. And then at that point, I think that the judge, bringing in a special master or the court's own expert, may make sense.
To Peter's point, the disagreement is so often at the level of a value judgment. And if you have able experts on both sides, I don't see what a court-appointed expert is going to bring to the table that is going to allow the court or a jury to be better equipped to make a value judgment. So where both sides are represented by experts, I think the way the cases look right now, we have about as much as we could want for expertise before the decision maker.
Yeah, I would just add, I never appointed an expert in any case, in the IP area or others or other areas. The parties would certainly bring their experts. I never felt the need to find someone to break the tie, so to speak.
Thank you. Okay, let's move on to the professors. Now, I'm going to actually ask the personal question first, because I think it's informative to just set the context. Both of you, actually, unlike many of us in IP, actually have some industry, and in Joe's case, actually trained in music. So tell us how that background, and just for the benefit of the audience, Christella was director of the Universal Music Group, and she was director of business development at MySpace Music, and Joe was also, while in practice, dealing with music cases. How has that background coming into academia informed your scholarship?
Well, I can say certainly for me, it's been a fruitful source of topics, right? It is still a place from which I grab a lot of interesting examples and goings on in the industry where I hope that I can offer some insights and inner workings of like what might be going on. I test some theories and that kind of thing. And also, at least so far, has also afforded me some access to folks on the inside that I can run these things by and ask them, like, what do you think is going on? And what else might explain this sort of thing? And so I found that to be something that is a bit unique to my situation coming into the academic side of things. A little more, I think I probably write things that have a little more case studies and a little more of a practical feel than theoretical, for better or for worse at the moment. But I think that's probably been the biggest influence.
Thanks, Celia. Joe?
In my case, so my time in practice when I was at Jenner and Block, I was working on copyright cases, but they were more like royalty disputes or mass infringement cases that aren't really what we're talking about today. But in terms of my educational background, I mean, I think the most interesting thing for me studying musicology before going into law was just how it never, the kinds of questions we're talking about here, like is a particular similarity substantial? It just didn't come up, right? We would talk, music theory was about like, let's break down one piece. How does it work? How does it tick? What's going on underneath the hood? And you could look at it in context of other pieces that inspired it or were inspired by it. But that ultimate value judgment step of, well, do those similarities matter or not in some kind of normative sense? We just didn't talk about it. So the absence of that, I think, is the thing that sticks with me the most in seeing how much lawyers do talk about it.
Thanks, Joe. An exciting development, of course, is the two of you got together and decided to write an article on music copyright. And you titled it Authoring Prior Art. So tell us, what are some of the 2 or 3 takeaways that we should know after today about your article?
Okay, so we'll be a two-headed monster on this. I'll start and then pass the baton over to Christelia. But the gist of it is that for most of copyright history, up until let's say about 10 years ago, defendants would from time to time try and make arguments that their copying should be excused because the stuff that they had copied had already appeared in all sorts of so-called prior art. A term that would look familiar, not exactly the same, but familiar to patent practitioners. Up until 10 years ago, that argument always lost. US courts would just say, like, who cares? Copyright doesn't have a novelty standard. So unless you're going to show that the authors themselves actually copied from those pre-existing sources, we just don't care about them. But that's changing in a number of recent, specifically music copyright cases. In those cases, courts are looking at pre-existing sources, not just to ferret out whether copying has actually occurred, which is sort of uncontroversial from the perspective of traditional doctrine, but more interestingly, that it's being used to argue that an alleged similarity isn't actually all that substantial, right? A similarity is going to be more substantial if the author's expression is really novel, and less substantial, maybe even just not worth our time, if the author's expression turns out to have been done before. Priscilla, do you want to?
Yeah, so I would say, so having made that observation and noticing it, and by way of background, Joe and I really got together and started thinking about this during a conference that I put together and hosted at Colorado Law right before the pandemic kicked in, where we had a bunch of forensic musicologists and copyright litigators discussing cases, and over again in their analyses, we kept hearing them talking about prior art, and thought that was quite curious because as Joe just explained, the courts and commentators, scholars in particular, I would say, would have said, well, that's not a thing, right? There's no prior art and copyright because we have the independent creation doctrine, and so who cares if there was something prior? But clearly it was, there were folks who disagreed. So we, upon making this observation, we started by looking at all of the documentation, all of the expert reports and rebuttals, and all of these music copyright infringement cases from, the mid-90s to the present. And we developed a theory and tested it through a bunch of interviews, that there are a number of factors contributing to this, the evolution of prior art and copyright, but that at least a primary driver were the forensic musicologists themselves, right? And we, a few observations, of course, the forensic musicologists, as we've been talking about here, are very highly specialized experts, right? Who know two very niche fields, musicology and also copyright infringement, specifically substantial similarity analysis, right? Importantly, there's very few of them. We identified about a half a dozen active experts whose names you see over and over and over again. And we interviewed almost all of them, and observed that one of the norms that they've developed, understandably in a small repeat player group, is to read each other's work. So there's a lot of sort of sharing of the knowledge, and a shared view that their central role for them in these cases was to either present or rebut prior art, right? And even the plaintiffs who disagreed with the prior art that may have been presented by the defense, for example, didn't disagree that prior art played an important and relevant role, right? In other words, the conflicts weren't over whether prior art counted. It was just, which prior art was applicable in a certain space. And so we found, I think that the third of our important takeaway points would be the prominent role that experts play in the development of this phenomenon.
Thanks, Crystalia. And you actually also quote somebody on this call. So you quoted, the two of you quoted Bob Clarida. What did you say about Bob, and what did he disagree with?
Uh-oh. We said Bob is great.
We can do some fact checking there. It's in the article.
A random paragraph in the paper where we talk about nice things about Bob.
So Bob had written an article. Correct me if I'm wrong. I think it was for a symposium that Columbia did on the savoir-faire doctrine. Which I think for people that are in the weeds of copyright doctrine, right, that's a natural thing to compare what we're talking about to. Talking about how savoir-faire works and would be different from the kind of thing that we're talking about. So when you're dealing with a savoir-faire case, a lot of courts are really looking, or the Ninth Circuit and Swirsky, to take a music example, have said you need to be looking within the genre. It's not just kind of like a free ranging search. Can I find something anywhere that looks similar to what the plaintiff is asserting rights in, right? It's supposed to be something that falls within the same genre that the author is working in, and there's not the same emphasis in the cases that Chris Bailey and I are focusing on here of making sure that we are within the same genre. So when experts are coming to court talking about prior art, they could be looking at a pop song in the context of another pop song, but they might be looking at folk music from another country. They might be looking at Western European art music from a couple centuries ago. It's really more of an anything goes terrain.
Right. And I think another distinction that we note in the paper between the traditional doctrine of sans affaire and what we are beginning to see as these prior art cases and copyright come out is, for lack of a better term here, like the numerosity requirements. Sans affaire is really focused on something that is, a standardized commonplace element in a different way than we are seeing in some of these prior art cases. Take Peter's recent weekend case, right, where 3 pieces of prior art were sufficient to show that this musical element may not be substantial, right? And so that's quite different than you would quite a ways away from something that sans affaire would call standardized for the genre.
Thanks. Bob, do you want to respond?
Oh, right. No, and I thought it was a terrific article, and it goes a great distance toward something that I think is important, which is to sort of disentangle all these really similar overlapping concepts that the courts often sort of jumble together. And I think the article does a great job of helping to disentangle that in the field of music. But there are these various limiting doctrines. You've got idea expression, lack of originality, sans affaire, thin copyright, building blocks, more discerning observer. And they're all sort of trying to do the same thing, but they've all developed their own sort of methodologies for doing it. And it just sort of turns into this soup after a while. And I think it's really important to try to keep it from doing that. And in the case of sans affaire, for example, I think the genre limitation on sans affaire is really important. The whole concept of sans affaire is, well, if you're doing a Western, you're going to have a shootout on Main Street, and you're going to have people riding horses, and you're going to have, a fight in a saloon or whatever, because that's what is in Westerns. And if you have those things in your Western, it won't be because you stole them from the plaintiff. It's because that's what Westerns are. And I think that's a valuable thing. And that's different from saying there's one thing out there that does also have a horse and a saloon and a gunfight in it. But it was a completely different sort of work in other respects. So I think the article is terrific, and I would commend it to everybody. And I think music is particularly vulnerable to that sort of thing, because the stakes are often very high in these cases, and musicology experts are going to go out and find that prior art, and they're going to find a lot of examples that maybe really could be filtered out, I think, by the court, if they're not particularly relevant to the genre that the piece is in.
Thanks, Bob. Now, one thing, Peter, go ahead.
Yeah, I was just going to say, first of all, on the case that Professor Garcia mentioned, there's something that isn't reflected in the Ninth Circuit opinion, which is that each of the 3 plaintiff songwriters knew about at least 2, sometimes 3, the 3 songs before they composed theirs. And one was, Blondie's Heart of Glass, which was a #1 hit, and the guy really liked that song, and the music was almost exactly the same as that song. So there was another element, but I would agree that and sometimes prior art, people push back on prior art because of this idea that if someone in a deserted island writes Romeo and Juliet, they can claim copyright in it, even though so. But what we usually use prior art for is to show that these are elemental musical building blocks. And so, for example, a chord progression of 1-4-5 appears in half the popular music in the U.S., in the world. And so, it's not so much saying that it wasn't independently created, but even if it was independently created, what was what it is just a musical building block that no one can have a monopoly on, because then a songwriter couldn't have a chord progression of 1-4-5.
Thanks, Peter. Now, one thing that you mentioned in the article is this change is really in response to a couple of things. One is latches, and how the Supreme Court eliminated latches in copyright cases, and that makes it easier to sue downstream creators. And also how the Blurred Lines case, actually, which you talk about, makes it more likely to find musical similarity between songs. Is this therefore a good way of addressing the issue? Well, we're going to start with the authors, and then we'll open it up to the rest of the panel.
Well, one of the things that Joe and I note in the article, and one of the reasons why we are inclined to think that this development of prior art and copyright could be a good thing, is because of, I think in one sense, it provides a valuable tool to judges and to juries for making sense of a otherwise often indecipherable doctrine of substantial similarity, where we don't have a lot of predictability. And importantly, and I know Joe alluded to this earlier, because so many of these music copyright infringement cases tend to either settle out or go to a jury, we don't have much doctrine around this, right? We don't know what it is. And we think that to the extent that the introduction of prior art can lead to more motions for summary judgment, where the judge tells us, yes or no, and here's why, could only benefit an area of law that really has a dearth of clarity around these doctrines. So in that sense, we view this as a potential positive.
On the previous panel that was focused on the other side of the Atlantic, there was some discussion of whether to focus on melody in particular as being like the real place where you would need to focus on your infringement claims. I'm a fan of that. I've argued in favor of that. I don't see it. We used to do it that way in the United States. I don't see it coming back anytime soon. At least that hasn't been the path that's been taken in all of these high-profile music infringement cases over the last couple of years. So that would be one way to achieve the kind of stability and predictability and allow for more cases to be decided on a dispositive motion by a judge. But if we're not going to do that, I think focusing on prior art is a perfectly good other way to do it, to the extent that, like Christelia said, it's a tool that judges can use, right? You have an expert on one side saying, this is substantially similar. You have another expert saying, no, it's not. Then this is something concrete that judges can look to and say, well, has this been done before, and has it been done before frequently? That would allow judges to understand the piece at issue, not just in a vacuum, but in its creative context. And I think it's that kind of contextualization that lets the decision maker make the value judgment that at the end of the day, deciding substantial similarity in these cases just ends up being, do I think this is wrong or not? Look what's been done before.
Thanks, Joe. And it just so happens we have a judge on this call that can weigh in. So
I just want to.
What do you think?
Yeah, I over the years, I've looked a lot at prior art. In preparing, I even found a case from 20 years ago where there's a section, in my opinion, entitled Prior Art. Was an easy case. The words was both words and music. The words were clap your hands, and the musical sequence was C, B flat, C. And the defendants provided many examples of earlier songs, writings, and so it was clear that these were not protectable. But there were other cases I've had as well. I remember the country and western song where someone used, if you don't stand for something, you stand for nothing. And I remember getting examples from the Bible, from Martin Luther King Jr. giving a speech. And it was very useful to me to see these examples of where these phrases or musical sequences have been used in the past.
Thanks, Judge Chen. Since we're going to move, or if we're moving towards a system that's more reliant on prior art, one thing, of course, in the patent system is registration. When you think about prior art and what's out there. So, Rob, I'm going to ask you this. Is it a good idea to relook or enhance our registration system, since this seems to be the way that copyright infringement is headed?
Well, I think the concept of courts and litigants bringing in issues of prior art is a good idea. I'm not sure that I don't think that fits well with copyright registration, and just because of the differences between copyright and patent, where, you know, as Judge Learned Hand said long ago, that two people can write Ode to a Grecian Urn and both get copyright. That's independent creation is essential to copyright, and it doesn't, you know, require novelty. So for us, for the registration system to get into that, I think would be problematic. But I do think that there is great value in being able to identify, you know, prior uses, as Peter said, as discovering those building blocks in the past that have been used, whether that's phrasing or genre-based types of uses of works, could be exceedingly helpful in litigation.
Thanks. You know, in a sense, though, people already are looking at copyright registrations and infringement cases, especially when they deal with useful articles. And they're saying, well, they've actually indicated this is what's copyrightable and what's not. Wouldn't that be tremendously helpful as a general rule for courts to take into account in the same way that you would in a patent case? What is prior art in the context of a copyright registration?
Well, in terms of useful articles, we're just the test is just distinguishing between, you know, is it a useful article, and if it is, then are there separable copyrightable elements? But it's not looking at prior art in that context. And there's nothing that I was saying about prior art and registration that in any way saying that courts should not look to registrations. I think registration plays a very important part in trying to assist not only applicants but courts as well understand issues. And even though it's always dealing with the work as a whole, which very seldom is the issue in a music infringement case, we're almost always talking about a very small piece of the work, and that's not something that the registration system could ever help with. But I think in some ways the correspondence that could go on between examiners and applicants can be important and can provide important information, or at least emphasis on issues that may be relevant, even if the work is registered, that for either the defendants or the court may want to look into farther, because there's many things in registration that are not addressed and that are left to the court to decide. For instance, there is information about ownership. If the author is not, if the owner is not the same as the author, then we need a transfer statement, a short statement about how the owner obtained ownership of the work. But we don't look for proof of that ownership. We don't investigate the transfer or the contract. There are many things that courts are left to determine, and we just try and sort of parse the issues so that there is a little more clarity. And
Thanks, Rob. Okay, I'm going to ask a question from the audience, and then we'll go to the final segment of the panel discussion, which is round robin, where you all can talk about what the what current developments people should be concerned about, your thoughts on them, or future trends. But before that, question from the audience, and this one's been voted up. In terms of musical experts, would not a multivalent, multidisciplinary panel be most neutral, accurate? Do you guys have thoughts on that? So I suppose if I understand the question right, you would have a jury of experts or musicologists.
It sounds almost like they're suggesting someone, for example, you have a musicologist, a sound recording engineer, a producer, music historian. I don't know, but I mean, it's an interesting concept. But we generally only use a sound recording engineer in a sample case, where there's a claim that the actual sounds have been recaptured. If you start the approach by trying to identify what is the musical work, then you need a musicologist. The rest of them, a producer might be helpful, I suppose, in testifying as to elements of the sound recording that someone claims are a performance element, when in fact, or a compositional element, when they're in fact a performance element. But I'm not too sure that if your goal is to figure out what is the actual musical work, and then is it substantially similar to another musical work, I don't know that you would go beyond the discipline of comparative musicology.
There's another way that you could try and get at that, which is instead of changing the identity of the decision maker, you can try and change the identity of the perspective that the decision maker is supposed to adopt. So right now, our decision makers, whether they're judges or juries, are supposed to adopt the perspective of the lay listener. You could imagine a different test that said adopt the perspective of the average songwriter, and it would look very different, right? Whatever expertise we would have might go towards whether did this cross the line according to songwriters, who at the end of the day are the ones who are supposed to be getting that benefit of copyright protection. So do songwriters think this is okay or not, right? I could imagine a system like that, but it's not, as long as the lay listener test is what we have, that's not what we're doing. But I think if we're trying to imagine ways we could change things, we don't necessarily need to change the identity of the decision maker. We could also just change the question that we're asking the decision maker to decide.
Thanks, Joe. Okay. So in the last 5 minutes that we have, we'll start with Castalia. One current development or future trend people should be thinking about.
Well, naturally, I'd say prior art, right? And I think that, even many of these recent cases, right, even the pending cases, suggest that it's something to pay attention to. While there are other things at play, right, the recent affirmation in the Dark Horse case, this is the Katy Perry case, I think, among other things, there is a discussion of prior art, again, presented in a very distinct way from Sans Affair. I think the, popular news pieces that we're seeing now, the Dua Lipa levitating case and the pending Ed Sheeran case, like all of these are going to involve, among other things, prior art. And I think that paying attention to the way that it develops both in the circuit courts and as we're now seeing in the Ninth Circuit is something to really pay attention to. And it remains to be seen how or whether it will be adopted, and how broadly outside of the music context. But I think that's worth keeping an eye on as well. Joe and I did find a few cases here and there outside of music where it was happening, but clearly the action is in these music infringement cases.
And thank you to Joe and Crystalia for the shout out in footnote 209. So, and with that, Joe?
Yeah, so I want to be keeping an eye on whether we start seeing different results in cases where the claim is over a short snippet versus where the claim is over the entirety of the song, right? So like Led Zeppelin was about a very small part of the song. Katy Perry was about a very small part of the song. Blurred lines, whatever problems some people might have with the outcome, one thing that case was that made that case different than the others is that it was about the whole song, right? The theory of the case was at an aggregate level, like everything about this song can be matched up to something in Marvin Gaye's song, and I think that case came out the way it did for reasons having really nothing to do with the music, or at least the personalities of the people that were involved, the testimony, the way Pharrell and Robin Thicke appeared to the jury had a lot to do with the result in that case. So I'm not saying that this explains completely what happened at trial, but at the level of precedent, I'm looking to see whether we start seeing more quick dismissals in cases that do involve those short snippets, like some of the recent dismissals we've seen, and no quick dismissals in cases that involve a claim over the entire song, where it's harder to just kind of say, well, this little snippet is a building block, right? I think that's a harder defense to make when the whole song is at issue.
Thanks, Joe. Rob? And by the way, somebody was interested enough to look for the article and is asking you to validate if that's the correct one.
I will do that in a second. I think I would go back to one point that I made earlier, is that the shift from fixation of musical compositions in written form into now submissions by registrations that are comprised of deposits that are phonorecords under the Copyright Act, fixations of sound, which also would constitute sound recordings that and because of the requirements for published deposits often being the first publication of the musical composition being in the sound recording, that no pun intended, it blurs the lines between the musical composition and the sound recording. And moving forward, that's going to be a harder issue to separate, as no longer we're getting those. And I think Bob had some recommendations in the article that he wrote, and I think there is much to be said about how ways in which musical composition songwriters can fix their works without confusing those two issues between the musical work and the sound recording. You could have the musical composition authors fix their composition on a phonorecord without the eventual embellishments by other performers, for instance, in a band or the producers or other things, where you just have a phonorecord fixation of the author of that musical author or authors of that musical composition. That would provide a clean record, and as I think is always the best case, is to register early and register unpublished, so that you have the earliest benefit of the statute and available remedies.
I'm glad you got a plug in there for registration. I think Shira would be pleased. Yes, Bob?
Yes, to pick up on what Rob was saying, and I do touch on these things in my paper that's in the materials here, but there is a workaround that I talk about that the Copyright Office endorsed in its amicus brief in Skidmore, which is to supplement an earlier very sketchy deposit copy lead sheet with a sound recording, and that's something that the Copyright Office has done. You can't get two registrations for the same work, but you can in fact register, and it, the example I give is there's a registration for the sound recording of "Sympathy for the Devil" by the Rolling Stones that was registered in 1988, the sound recording, as an arrangement of the composition "Sympathy for the Devil." And the basis of the claim, the new matter claimed in that, is arrangement and revised melodic line, because apparently the melodic line in the lead sheet that was originally filed was not correct, or not completely correct. And it cites the previous registration, 1968, date of creation 1968, date of publication 1978, January 1st, because as under the statute, that was the date of the publication of that sound recording. So I think that's a way that the sort of negative consequences of the what I call the Zeppelin holding about limiting the composition to the deposit copy. I don't think that's a good idea. You don't do that with software. You don't do that with other kinds of works. And because the 1909 protection for music only attached to written representations of the music, I think there's a lot of undeposited authorship out there that if someone were to infringe it, it would be very difficult to bring a claim on, and I don't think that's right. And I think that's sort of letting the dead hand of the formalities of the 1909 Act carry forward way more than they should. So certainly it should be possible to do that sort of thing to get that authorship registered and be able to support a copyright claim. And I'm thinking of something like the guitar intro of Born to Run, which is an example I give in in my paper. It's not in the deposit copy. The deposit copy just starts with a vocal melody. That guitar lick is a very important part of Born to Run. I'm sure we can all hear it in our heads. And if someone were to infringe Born to Run, just that guitar lick, as it now stands, no one will be able to bring a claim on that. And I don't think that's a good idea. So
Thank you. Peter?
Yeah, first I just want to say that I think Joe's absolutely right about blurred lines being driven by the personalities. And the best proof of that is the jury found Fick and Williams liable, but not Universal Music Group, which distributed the record, which makes no sense at all. It's basically an impossibility under copyright law. I also want to thank Joe for not correcting me when I said 1-4-5. It's actually 1-3-4 chord progressions that are commonplace. I think what I'm looking at and what I think may happen is also something that Joe mentioned, which is historically melody was what was protected, and Learned Hand famously said, it's melody, that's it. And that sort of is accreted to rhythm and chord and harmony and other elements. And what you see in Skidmore is it knocks out some of those. And what you see in the Katy Perry case is they repeat that chord progressions aren't protected. You can't really protect rhythm. So by what we're moving towards is a system where hopefully, I think, because it makes sense, is where melody is the key in these cases. And getting back to something that Rob said about how people listen to a sound recording, they really don't know what the melody is. The melody is what we can whistle, and if you talk about a song to a layperson and they whistle it, that's what they're doing. They're whistling the melody. To me, that's provides clarity in the law, avoids a lot of the performance issues, and really is what the song is about. Everything else is orchestration in a sense.
Thank you, Peter. Judge Chien, you have the last word.
Thank you. I'm always nervous when I'm asked to speak on these IP panels because I am not an expert and I'm being thrown into a mix with all of the leading experts. But and I would not opine on where I think the law ought to go. I would say this. Yeah, it's interesting to hear about whether fair use is being extended or being pulled back. As a judge, I do not have an agenda. I decide the case in front of me as I see fit under the law. And then I leave it to the academics and the experts to try and figure out what we are doing. But for me, it's important to keep the big picture in mind, the purpose of the Copyright Act, and to do the best we can. And finally, I would say, come to New York and come to the Second Circuit. You'll see that we'll treat you well.
Regardless of when or where it was created, musical expression, the public domain or otherwise, always comprises some combination of fundamental elements of melody, rhythm, and harmony. Other elements, like tempo, instrumentation, timbre, dynamics, etc., may contribute to musical expression, but their significance is always secondary to that of melody, rhythm, and harmony, without which they have no meaning. Western music notation, developed over hundreds of years, enables precisely documentation of these fundamental elements, as well as secondary elements, in a visual format we call a score. Just as a visible verbal text captures all the protectable literary expression of a dramatic work to be performed on stage or screen. An accurately rendered score efficiently documents all the protectable expression of a musical work. Infringement allegations of musical works, therefore, should be adjudicated with reference only to these visual musical records and without consideration of recorded sound associated with any particular performance of these works. In fact, works whose value depends upon a particular performance of them, particular performances of them, contain less original musical expression than works whose value is independent of any performance. The fact that we have no audio recordings of performances of their own works by Mozart or Wagner, for example, has not affected the enduring or inestimable significance we ascribe to their works. Only by a similar uncoupling of the musical expression of a work in any genre from stylistic elements of a performance of it can we anticipate extricating ourselves from the increasingly chaotic jurisprudence in the area of musical copyright infringement in the US and elsewhere in the last few decades. Thank you very much. I will pass things over to Bob to wrap up.
Excellent. Well, I do not have written remarks like that. So I mainly just want to once again thank both Daryl and Charles for the organization, but also the panelists and the audience. So I want to thank you all for putting together, in the end, a fantastic several hours of delight for me, being selfish about it, and wish you a wonderful rest of your Friday, depending upon where you are in the world, possibly Saturday morning by now. And I will then leave the floor to Daryl. Thanks.
Thanks, Bob. Yeah, I want to join my co-organizers in thanking all of you for your engagement. I think it's really your questions, your participation, both on Remo and on social media. I was tracking your discussions. I'm glad that it's gained traction. It's ignited some interest, and I hope you'll continue these conversations. I think we've learned in the course of just a few hours how copyright law is both similar and quite different in different parts of the world. And I hope that this will be the first in many such conversations. I know Bob and Charles are thinking already about 2023. So stay tuned for that. And I also want to thank all the speakers who have taken the time to join us, and the student ambassadors and Adam for helping keep the train running. So with that, Adam, the floor is yours. Thank you again, Bob, Charles, and thank you.